May I have your lordship's kind leave to mention one matter for non-prosecution.
or non-prosecution? Monday? Monday to mention. Yes.
Lordship, may I to leave to granted to file an petition and move the same on Monday and mention matter.
Monday.
May I have my lordship?
Leave. Leave granted.
Leave granted. Somebody mention matter.
This matter tomorrow.
Tomorrow.
Extremely urgent with regard to Jalpaiguri matter. Jalpaiguri bench is not sitting today, and next day also. I cannot wait for a day. I am an applicant. I submitted my application. Forcefully, I have been given 1 marks lesser, and the appointment letter will be given within a day or two. I want to move it tomorrow as mentioned matter. Leave be granted to move this.
We have already served the private resident. Tomorrow.
Great.
Your Lordship, may I have your kind leave to mention one matter? This is WP number 16390 of 20212. We are for the respondent.
Group 8.
Urgency 2012. Group 8.
Group 8.
The urgency is that the respondent the petition is enjoying interim order. The issue is that the Port Trust own land. They are suffering monetary loss day by day. Kindly
Port Trust land.
Port Trust land.
Port Trust land, there is not group 8 matters. I want to know whether this is within my determination or not.
That I have to check once.
You take instruction.
I have to take instructions. I will come back.
Yes.
Your Lordship, may I be permitted to mention it's a matter of restoration application, Your Lordship. It was dismissed for default in 2023, Your Lordship. There's an urgency, Your Lordship, that due to the dismiss for default.
Dismiss for default, which matter? Group 8
Your Lordship,
or appeal? What is the number?
WP, it's a writ petition.
Writ petition. Whether it is group 8 or group 6. 2023, I have group 6 determination. You take instruction.
Your
And
Lordship,
come.
Your Lordship, may I be granted to mention this is for the correction. The matter was heard on 7th April, sorry, and the state was represented by the learned advocates, but it was not recorded in the order sheet. Please keep it as to be mentioned for correction.
Monday.
Highly
May I permit to mention 2 matters, my lord? I have served notice upon the other
What matter?
group 2 matters, my lord.
Group 2.
No, group 1. Land
Group
matter.
1.
Yes,
For what?
For inclusion in the list, my lord. Old matter, my lord.
Under hearing.
2019 matter under the heading motion.
You are the petitioner.
I am for the petition.
Readings complete.
Yes, my lord.
Have you served notice?
Yes, I have served
Okay.
notice.
Okay.
2 matters.
List it.
Motion.
Lordship, may I be permitted to mention one matter, group 1 matter, Your Lordship. Your Lordship, in this matter, the WBIEDC West Bengal Industrial Infrastructure has allotted a land to me and taking monthly rents from me. But due to some error, Your Lordship, they are not letting me use the land. They have blocked the land. And it is very urgent because my investment is.
Have you filed it?
Yes, Your Lordship.
So what you want?
Inclusion.
Inclusion in the list. Okay. Yeah.
Land matter, my lord. But this is my lord already heard out by Justice Lorenzo Rai, my lord. But my lord, due to change of determination, my lord, the hearing.
Okay. Inclusion in the list.
I have get
How many matters?
2 matters.
2 matters.
I have served notice.
Call the list.
Madam,
I am for the petition.
I'm the respondent, all company, my lord.
Mrs. Roy and Company and others versus Indian Oil Corporation Limited. Okay, I'm reading out only the operative portions of the judgment.
My lord.
Relevant portions of the direction of the Honorable Division Bench was quoted. It is the observation of this court that this portion of the observation by the Honorable Division Bench makes it abundantly clear that the firm can be reconstituted on the basis of past and present performance with regard to its business. There is no instances of complaint or illegalities on behalf of the petitioners in respect of performance of business of the petitioners with the respondent authority. Thus, the observation of the authority in the impugn order is itself unreasonable and arbitrary. Moreover, it is purely unjust and unreasonable for the respondent authorities to quote clause 42 and 46 of dealership agreement dated 29th of July 2009, which at present has no existence. Under the above observation, I find no justification and reasoning in the impugn order dated 9 July 2019 passed by the competent officer of the respondent authority. Hence, the same is set aside. As the respondent authority has not passed the reason order in terms of the direction of the Honorable Division Bench of this court in its true letter and spirit, thus they are hereby directed to allow the reconstitution of the petitioner number 1 with surviving partners, petitioner number 2 and 3, by passing a reason order within 3 weeks from the date of communication of this order. The reason order should be follow the directives of the Honorable Division Bench of this court in APO 43 of 2013, as well as direction passed by this court in its true letter and spirit. Under the above observation, the petition disposed of.
I'm deeply obliged. Well, it's Roy and Company problem, my lord, the cost item.
Messrs. Roy and Company and others. Next. কি হচ্ছে? হ্যাঁ? আজ কত তারিখ? 16 তারিখ। Call the list.
I Lordship, I am for the claimant apply.
Yes, what happened, Mr. Banerjee?
Kindly Lordship, come to the fourth line of this judgment, Lordship, where it has been stated,
I cannot hear it out.
Lordship. Fourth line, Lordship.
Fourth line,
Fourth line of impugn judgment,
page.
page number 1, Lordship. First page, Lordship.
Yes.
Where, Lordship, it has been stated in MSC case number 774 of 2008, 8, Lordship. It would be, Lordship, 474.
474.
MSC case number 47.
Not 774.
Not, Lordship.
474.
Lordship.
Okay. This much.
Lordship. Correct.
This matter appears for correction in
the
the judgment dated 23rd November 2023.
ওই জাজমেন্টটা দেওয়া আছে ওখানে, জাজমেন্টটা দেওয়া আছে ওখানে।
In the fourth line of first paragraph of the first page, the MSCC case number would be read as within invited comma 474 instead of inverted comma 774. দুটো inverted comma 474 টা inverted comma 774 টা inverted comma. The remaining portion of the judgment should remain unaltered. The office is directed to make out the correction in the body of the judgment itself. Next.
Item number 6, before my learned friend starts, I would like to congratulate your lordship for being
What?
confirmations of this High Court.
Thank you.
We are proud of your lordship.
Thank you. Thank you.
This is my,
What is this matter?
this is my
So this is the lordship make recall. This is the matter of EPOS machines, whereby the advocate general is appearing. I have taken time. Lordship was pleased to fix the matter on 28th. This is another matter whereby my lord the advocate general is appearing. Lordship is pleased to fix the matter on the same date, 28th.
Okay.
matter has been fixed on 28th. I filed this application and mentioned this matter before you, considering the urgency. There was a kindly straightway come to page 33.
Your urgency in the application can 1.
Can one. Kindly come to page 33.
Can one.
Can one.
কত number page না?
33. 33. May I read well? This is dated 28th March 2025. What they have said, the Department of Food and Supply has already directed by memo number such and such weighing scale during the distribution of
পড়তেই
food
পারছি
grains. The status report of March 2005 on the using of weighing scale has been enclosed here. From the report, it has been noticed that the SR area, the FPS dealers are using the weighing scale during the distribution of food grains. Food grains is found to be miserably poor. Once again, you are requested to take necessary measures to ensure full compliance of the direction to keep weighing scale by 100% FPS set forth by the department without any delay. Also, it has been directed in serial mode 2.8 in the minutes of the video conference held on 18 March that the FPS with lowest fuel be identified and so-cause notice to be issued to the said FPS followed by the imposition of penalty as per provision of the control order. Now, let us kindly come to page 31.
31.
31, that is what is 2.8. Monitoring and use of weighing scale. All SCFA
Now, what is this? Minutes?
minutes, you will see it's
Well,
Video
this actually held between the millet, the
starts
FPS
from
dealers
page 29.
and the government.
Okay. Okay.
Thereby, millet, somebody have come to an amicable solution that how this can be done. Because this is the remote place, the targeted millet, the orientations are there millet. How this has been done? This is the millet, the gist of the same.
Okay. What is this?
This is the
Monitoring.
minutes of the meeting dated, you will also will get it on 29, page 29, minutes of the meeting dated 18 March 2020.
Yes.
Kindly come to page 31, 2.8.
Yes.
That has been referred in the memo dated 22nd March. All SCFS and ROs were requested to monitor the using of objective weighing scale FPS wise to improve the performance in respect of the RDS. DCFS of the South Nepal Mushar Postim Bardhaman are asked to monitor the usage regularly. It has also informed that the FPS with lowest should be identified and so-cause notice to be issued to the said FPS followed by imposition of penalty as per provision of the control order. And in one, you will also kindly come to the order sheets, which I have annexed. On several allocation, state has taken time. Now they are instead of, if had the matter not been taken time, that has been disposed of, I will entitled to get the additional commission, which has been. This is my main request. So on the
The
other hand,
additional commission,
Now,
whether
what is your prayer in the application?
well,
stay this memo till the
no,
restriction
this is millet. I would say millet kindly, yes, very well.
No.
That's my prayer is
No.
that
No. I want to know the situation here.
page 7.
You have participated in the
Page 7.
video conference,
Video conference, correct.
and there is a memo in terms of that video conference.
My lord,
So what is your difficulty? Let
But
them
it's
do.
not where I have not participated in the video conference.
doesn't matter.
No.
While 120 is saying
No.
doesn't matter. I have not
Just wait.
participated in the
Just
video
wait.
conference.
Everybody has participated.
2.8 is the directives upon the all SCFS and ROs
My lord.
to look after what is going on
So
there.
if I not do that, they will issue so-cause and penalty.
No. You why you said you will not do that?
Yes, I am ready to
FPS
do
with
that.
lowest use.
I am ready to do that, subject to they provide me the additional commission which I am entitled to.
No, that is the matter, sub judice matter.
that
That
is
is
the sub
cannot
judice
be
matter.
cannot
That
be
is the
decided
subject.
now.
What I am on, my lord. In one hand, they have taken time. You will also kindly see the order sheets.
No, I have not issued any direction to deal with the matters with the dealers or the distributors by the authorities.
I am not. I am entitled to get the additional commission for using of EPOS machine and EOing scale.
No, that is
That is the subject matter
your
of the
sub judice matter.
Sub judice matter.
So
Before you-
in the meantime, they are
In the
doing the
meantime,
doing
In the
the,
meantime, my lord, in the meantime, what happened, my lord? I have filed my opposition. They have filed their opposition in late. I have filed my reply. I am not on that. I have published the paper publication representing capacity. They have taken the time. In one hand, they are taking the time. On the other hand, they have issued the memo whereby if I don't use that, they will issue the show cause notice. I am very much interested to do that, subject to making payment. That is my point.
no, you are using EPOS machine now.
I have
Yes,
You are using
I
EPOS
have-
machine. Yes, no, that is the rule of the state.
I
You have to use,
I
you
have
have
My
to
lord.
use the EPOS
I
machine.
have
So this is the directives to read the 2.8. This is
Correct.
the directives upon SCFS, SCFS and ROs. So they have to monitor who are the persons.
If I don't do that, they will issue show cause notice.
Now,
and
what
penalty.
you don't do?
It has also been informed that the FPS with lowest
Yes, lowest use.
Lowest
So you are using.
be identified, should be identified and local notice to be issued to the said FPS followed by the imposition of
So
penalty.
it is not your case that you are not using the EPOS machine.
That.
Then why you are so suffer?
This is the representative capacity writ petition. There are some dealers who are not in a position to use that due to financial problem. They are not paying the my additional benefit in one hand, so that I can use it. On the other hand, they are issuing so
So there are some FPS dealers who are not using the.
would not be able to use that due to
Why?
financial problem.
They have to use this.
Alright.
They have to use this. The
They
EPOS
have to
machine.
use it. In sometimes this happen, man.
Okay.
Sometimes this happen.
So this is not the case before this.
No, this is not the case before your lordship. What happened? What happened, my lord? What I am on your lordship, kindly see the orders.
No, whether they have taken any steps like
But we
that.
are taking steps. Now I have the show cause notice which I have not annexed. I have the show cause notices. This is the show cause notice.
Millard, may I just cut short that there is a distinction. The rule is that the EPOS machine
Have to be.
has to be tagged with the Millard, the measured machine.
Yes, yes.
Now everybody using the EPOS machine. The difficulty is that what is my learned friend is saying, in order to tagging the two machine or connecting the two machine, the central government, whatever the money is coming, they are entitled to the part of the same. That is their case.
That is the case. That is
Not the
under
case of
subject.
any of the person that they are not using the EPOS machine. Had it been a case, the EPOS machine is not using, in that event, where is the transparency, Millard? I am asking myself. EPOS machine is the Millard, the basic or the genesis of the transparency of the Millard distribution system, whereby how many persons and how many the quantity is being distributed to the targeted distribution system has to be analyzed. There is no, this is absolutely crystal clear. EPOS machine is being used by everyone. The particular notification speaks of the using of the EPOS machine. It is not connecting to the EPOS to the Millard, the other machines. It is only the EPOS machine. Kindly appreciate the Millard, the distinction. Everybody is using the EPOS machine. Now the question comes, those who are not using the EPOS machine. That is not the challenge here. That is not the challenge in the writ petition.
So what is the prayer in the application?
Any penal and coercive action.
Yes.
বুঝতে পারছি কি?
Yes, Mr. Sarai, what you want now in CAN application?
Only thing is that matter has been fixed by your lordship and there
Yes.
is a division bench judgment also. Almost holding that the payment is not being made to us. On the one hand, my lord, we are not getting our remuneration.
which has almost admitted by the division bench. On the other hand, some persons, some members, when they fail to discharge their duties in terms of the government notifications, that is using a post machine or something else, show cause notices are being issued regular manner. What I am suggesting to your lordship, my lord, my learned friend is correct. These are not the challenge in the main
Yes,
litigation.
this is
Absolutely.
not
What I am praying before your lordship, 26 has been fixed. 28. 28. At least 4 occasions, adjournment has been paid for, we have never said. Your lordship kindly fixed it a peremptory on 28.
Well, may I say only one thing? Kindly have a look into the prayer of the writ petition.
Yeah,
once.
that's
no, that is
নেই,
the,
এটা দিচ্ছ না তো? ঠিক আছে।
So,
He is not present.
28, 2 p.m. fixed, kindly make it peremptory. Entire matter can be concluded on
okay.
that day.
So this can application along with the writ petition.
Absolutely. Absolutely.
Okay.
Can application
Have-
kindly
have-
record.
have-
না না বলতে দেবে তো, একটু বলে দিই না। But kindly record that this can application is beyond the scope of the writ petition. Because why I am saying so, if your lordship kindly take trouble to see the two prayer. One, the page 90
Beginning the
connecting
teacher
to the weighing device. EPOS connecting to the weighing device. Second, EPOS with the weighing scale and the daily work. So weighing machine is not the question here.
I know, that
What
is
is
not
it?
the, okay. Please take down.
No,
And-
no adjournment on that.
Yes.
আমি না
Can 1 of 2025. This is an application for appropriate order filed by the petitioner. Having heard the learned counsel for the parties, it appears that this the prayer in the can application is not directly prayer of the can application is not directly relevant to the merit of the instant writ petition. However, for the purpose of betterment of hearing of the matter, let the can application being can 1 of 2025 be fixed for hearing along with the writ petition. Let the matter peremptorily appears in the list on 28th of April for hearing of the instant writ petition along with the can application.
Kindly record something, my lord. So far the peremptory is concerned. Otherwise, my lord, we are suffering for last 2 years. Kindly say the date of writ
Today
petition.
The can application has been filed, Miller. We have taken twice. I must be very frank before your lordship. The advocate general is appearing, Miller. It is not in my hand. It suits his diary and
He is more than competent, my lord. Let me argue on
but
that
I
day.
am so obliged for getting such.
No, definitely, my lord.
No, Advocate General has been appointed in this matter, so how can
Well,
he?
No, that's true. But kindly say how many times
No,
adjournment.
the matter is that whether you have concluded your submission,
My lord.
whether you have concluded your submission.
He has concluded.
He has concluded.
Yes,
I have
yes.
and
Only the Advocate
Yes,
General is to.
28th preempt.
And division bench almost held that the money is due and payable to us. I can show to you.
Not that, Miller. I
Okay,
will
no, I'll do that.
Sir, may I find my reply to the
তুমি কি WhatsApp-এ
writ
বদলা
petition?
select করেছো? করে দাও।
Reply to
reply to
the
the writ petition?
affidavit.
Opposition.
তুমি আগে contact ছিল করছো।
Reply. Affidavit in reply on behalf of the writ petitioner to the affidavit in opposition filed by respondent number 1 to 3 are taken on it.
ঠিক আছে।
My lord, we are very
Peremptorily
happy.
on
We are
28th.
very happy today after news. My
Thank
lord.
you.
All everybody, my lord. We are congratulating you.
Thank you.
Your Lordship, there is a minor correction in the judgment passed by Your Lordship on 18 March 2025.
Yes.
In the paragraph number 6,
Page
3, Your Lordship, in the paragraph number 6, where you are directed to respondent number 6, that will be respondent number 7.
item number 7.
Yes, yes, Lordship.
No, I have directed divisional retail head. He is the respondent number 6,
Should be respondent number 7.
7.
not the divisional retail head.
No.
It would be Deputy General Manager Operation.
Operation.
He is the authority.
Is your
Okay. Please check down. This matter appears for correction in the last paragraph of page 2 of judgment dated 18th of March 2025. The direction of this court to dispose of the matter should be upon respondent number 7 instead of respondent number 6. Accordingly, the last paragraph first portion of the last paragraph of page number 2 should be read as follows. No, should be read as follows. At the second line, the divisional retail within inverted comma, the divisional retail head within bracket RS, Indian Oil Corporation Limited Holdia Division, being the respondent number 6. The inverted comma says column should be deleted. In its place, within inverted comma, the Deputy General Manager within bracket operation, bracket close, Indian Oil Corporation Limited, Marketing Division, Holdia, Terminal 2, Terminal B, capital B, River Ring Road, Khanjanchok, Holdia, comma, being the respondent number 7. Inverted comma is correct. Should be inserted. Rest portion of the judgment will remain unanswered. The office is directed to make out the correction in the body of the judgment itself within a fortnight.
Lordship, kindly extend the period.
Next part, the authority, last part, the authority to dispose of the direction has been changed by the order of this court. Thus, the concerned respondent number 7 shall dispose of the representation within 6 weeks from the date of this order. Instead of direction in the impugned order.
Lordship.
I express the knowledge to your lordship and your lordship's officer.
To one workshop.
My lord.
According
May I file, my lord?
to my lord, I filed the contempt application against the register ILC of
What is the number?
number.
It need not require, my lord.
However,
We tried our level best to comply with your lordship's order. If then, at the time of calculation of provisional pension, there is a difficulty, my client will, without hesitation, will extend all cooperation.
Now, let me hear it out. What is the number so that I can tag both the matter. Otherwise, it cannot be possible to separately deal these matters.
Kindly short password, my lord.
Why Passover?
Kindly-
Have you served this?
Yes, I
Whether they
saw,
have
I
served.
saw.
What is the number? At least same,
Hello.
give me the number so that I can tag the matter.
Yes, my lord, CAN 1 of 2025, my lord.
CPN 1 of 2020.
5 and CPAN number 1038 of 24, CAN number 1 of 2025, my lord.
number at it.
Yeah, CAN.
One, na?
Is it can?
One.
Contempt.
Yes, probably.
No contempt is appearing in the list. Only one contempt 1038.
No, it's not. No, my lord, no, it's not. I'll note that.
Okay, very well. What you have done? Have you
Yes.
reached there?
Yes.
Whether Mr. Ganguly they handed over?
I have to take instruction in this regard, my lord.
Yes.
Next week, any date, my lord, that should be
Okay,
allotted.
okay.
I'll come up with.
So no, Mr. Mukherjee, what you have done? Your client has gone to the office of the Mr. Ganguly
Yes.
and you handed over these documents.
Yes.
Original
All
service
available
book,
documents, my lord.
depreciation,
We have
everything.
handed over.
You have given to me.
Right.
Can I have a copy of this? my lord?
Yes,
আমি
you,
জেরক্স
sir.
করে নিয়ে দিচ্ছি তোমার হ্যাঁ
You give
কোথায়
him a
দেবো
copy
নাম্বারটা
so that he can take instruction.
yes yes my lord in
Very-
course of the day I shall
Okay,
okay
okay, Ms. Goswami, you give me the number.
Yes,
I'm
my
passing the
lord.
order. I'm passing the order, tagging the matter. Let it appear in the next week, okay?
Yes.
Now, should I file any opposition it's not required
Not required, you just wait. You have handed it over.
yes sir.
Very well. Let him take instruction what is they have done.
my lord এরপর দেখি যদি কোনো ক্যালকুলেশন করতে অসুবিধা হয় না
Read petitioner submits
হ্যাঁ
that in pursuance to the direction of this court, he has preferred a contempt application against the register IIEST. Simple. Let the contempt application number 10 be tagged with the instant CPN number 1038 of 2024. Full stop. Mr. Mukherjee, learned senior counsel, appearing on behalf of the register IIEST Sipur, submits that in terms of in pursuance to the direction of this court, the register IIEST Sipur has handed over the original documents as required by the alleged contemner to the office of the Director, Technical Education, West Bengal, at his office at Vikas Bhavan, Salt Lake. Full stop. Having heard the submission of Mr. Mukherjee, let the matter be adjourned today. List both the contempt application on
calendar
April 30th.
April 30th
30th. April 30th under the same heading.
my lord
Mr. Ganguly appearing on behalf of the alleged contender to take instruction regarding the service of the documents by the registered IIEST Sipur.
and this will be not possible not debar them for making calculation
The document pertaining to the copy of letter of register IIST Sipur along with the copies of the required document be taken on record. Next.
my lord
At 9 and 10, I'm praying for a very short passover, my lord. Very short, the file is coming. Very short.
I am praying time because I have not received instruction, my lord.
Well,
Only
it's
not
my
today, not
2030
tomorrow.
notification, my lord. Vacancy notice.
When I appear on behalf of the petition.
Item number 9.
No, 10.
10.
Okay, you wait. Let him first. Okay, pass it over first.
Very short.
Item number 9, pass over.
9 and 10. 9 and 10.
Yes, item number 10. What are you?
No, 9 and 10. I thought of that I was appearing in 10, but actually I'm appearing in item 11.
Okay, just.
Item 11 for the sticker.
Okay, item number, call item number 11.
But item 11. I appear on behalf of the petitioner. This is the matter where my lords will be pleased to find that a notification was published on 10th of May 2024 inviting applications for grant of license against the vacancy of fair price shop.
Okay.
Now that my lords will be pleased to find at page 27 to 30. Now, your lordships will be pleased to find that so far as the present matter is concerned, 7 candidates submitted applications pursuant to the notification, including the petition. Now, the eligibility criteria, that is the main sheet anchor of the matter, that my lords will be pleased to find at page 28. It starts from page 27.
Yes.
Now, page 27, kindly see the details of the location of the vacancy, villages, Hamlet Para, service area, then Gopalpur, Jogiar, then central location, Holdibari MSK school. Now, kindly skip open the next page, page 28, the eligibility criteria. In the eligibility criteria, Millard, it was specified that the applicant must fulfill the following eligibility criteria. The applicant shall be an individual permanently residing in Islampur subdivision, registered partnership firm, registered cooperative society, Sangho or Mahasangha self-help group working within Uttar Dinajpur district. Then, Miller, I draw to my lord's kind attention to number 4. Requirements of size of godown and shop for running ration shop. Then the applicant should possess suitable shop godown having the following norms as per the notification issued by the Department of Food and Supplies by 1465 FS dated 10/4/2023.
Yes.
Miller, I'll be placing that notification. Then Miller, kindly come to straightway, kindly come to 6. There has to be adequate space in front of the godown for unloading of stock. Now, so far as my contention is concerned, Millard, first of all, Millard, the house of private respondent number 11 is at village Gopalpur. That, your lordships,
House of private respondent at village Gopalpur. That is not within the Islampur subdivision.
Millard, this is within Islampur subdivision. That I cannot say. This is within.
Okay.
And the godown of the office of private respondent number 11 is at Jogiar.
Yes.
And the office of the private respondent number 11 is situated in Jogiar in the district of Uttar Dinajpur. There I cannot make any submission. Now, what are the points which I am bringing? The points which I am bringing is that, Millard, there was disregarding of the particular notification which I had shown to my lords, Millard, that is the notification dated 10th of May 2024, that is at page 27. If your lordship asks me, Millard, how it was not being complied with, my answer is the private respondent number 11 is having no road in front of godown in which no public vehicle can ply. Where from I will be getting this thing, Millard?
That is, you are saying no adequate space in front of the godown.
Yes.
This portion.
Now, when Millard, I will be getting it. I am in RTI was obtained. Now kindly see the reply to the RTI.
Page
853. Kindly see, here I start from the second paragraph. As per RI report, the distance of plot number 8 under Mauja Jogia, jail number 112, Kotian number 435, from plot number 15 under Mauja Jogia, jail number is 100 meters more or less. A 10-feet metal road from LR plot number 04 in Mauja Gopalpur, jail number 61, goes through on LR plot number 1699, 1700, 1698, 1697, 1684, and plot number 1682, and LR plot number 87 and 85 in Mauja Jogia, jail number 112. But a portion of the road that is 36 meters on the LR plot number 1697 is not metal, kacha, though the road has not been reflected in the LR map.
So what is
Yeah.
your contention?
Millard,
What is your contention?
my contention is that the particular, there has to be adequate space in front of the godown for unloading of stock. This has not been fulfilled by the private respondent.
No, how can you prove what is the number? What is the plot number of their
The plot number, the
plot number of their godown or shop
yes,
room like
I'm
that?
giving that. I'm giving that, Millard. Your Lordship may kindly consider that go down of the private respondent number 11 is at Jogia, and the office of the private respondent number 11 is situated also at Jogia.
What is the plot?
Now, the particular LR map, I have annexed the LR map also, that my lord will be pleased to find. There is one thing, Millard. Kindly see page 56. There is no mention of LR and RS map in respect of the road where godown of private respondent number 11 is situated.
No, I want to know what is the plot number of the godown of the private respondent number 11.
What is the
Plot number.
Plot number, Miller, just 1 second, Miller, kindly plot number, Miller, just a second. Plot number. Miller, I can only show to my lord's Miller from the particular Miller RTI, nothing more I have. This I must say.
No, RTI said that there are some portion of road, village
It is
road
kacha.
like that, kacha, whatever may be. But
Yes.
you are saying that your only allegation is that there are no adequate space in front of the godown of the private respondent.
And
How
also,
can you
and
prove that?
also my further contention is that Millard, a particular, there has to be a road where from the public Millard.
Yes, I understand. The vehicle has to be plied,
That
vehicle has to be plied and the supply has to be made.
I'm getting.
So
I'm
you are saying there is no such existence of road.
Yes. Therefore, Miller, on instructions I am submitting that he has a kacha road. So therefore, Miller, these particular vehicles cannot fly. Now, another thing which I will be also showing that Miller at this stage, what I did, Miller, an objection was filed by the landowners of Gopalpur Mauja. That your lordships may kindly come to page 55.
Objection to the concerned authority. Let them deal with that.
The Food and Supply Department.
Concerned authority.
Yes, authority. Now, dear Miller, your lordship may kindly, Miller, I permit me, Miller, to play. বিনীত নিবেদন এই যে আমরা নিপক্ষ ঠিকানা স্থায়ী বাসিন্দা নিম্নোক্ত তপশিল ভূমিত আমাদের পৈতৃক সম্পত্তি হইতেছে এবং আরো অংশীদার ও ওয়ারিশ রইয়াছে। উক্ত সম্পত্তি কিছু গ্রামবাসীদের যাতায়াতের জন্য এবং আমাদের যাতায়াতের জন্য কিছু রাস্তা দিয়াছি ব্যক্তিগতভাবে। আমরা জানিতে পারিলাম যে আমাদের বাড়ি হইতে 1000 মিটার দূরে একটি এফপিএস রেশন শপ ডিলারশিপ হইতেছে। উক্ত ডিলারশিপ হইলে আমাদের পার্সোনাল রাস্তার উপর দিয়ে মাল লইয়া যাইতে হইবে, কারণ আমাদের রাস্তা ছাড়া আর কোনো সরকারি রাস্তা নাই। ইয়াতে আমাদের আপত্তি রইয়াছে, কারণ আমাদের ও আমাদের অংশীদারদের পার্সোনাল রাস্তা দিয়ে শুধুমাত্র মানুষ জনের যাতায়াতের জন্য দেওয়া হয়েছে, সে কারণে আমরা পার্সোনাল রাস্তা দিয়া ডিলারশিপের মাল লইতে দিব না। And this was done by the persons of Gopalpur Road.
Very well. What is your prayer in the writ petition?
The prayer in the writ petition is, Miller, one thing more, Miller, just one last, Miller, can you
Yes.
permit me, Miller, I appeal to my lords. Miller, your lordship is very well aware of this particular of this particular notification that my lords is much there is a system of marking.
Yes.
Now, this has also, Miller, I have given that to you. I know that your lordship is very well aware of 9th of August 2021.
Yes.
Now, what was the marks given to me and vis-a-vis what was the marks given to private respondent number 11 is a matter of consideration. Now, Miller, my last point is that there is no government road in front of the godown of the private respondent number 11, for which it is not permissible for a private vehicle to reach godown of the private respondent. Since Miller, the same is a Kacha road. And your lordship was asking me what is the plot number. Miller, I find only the instructions which has been given is that the portion of the road that is 36 meters in LR plot number 1697 is not better. Is not better. That my lords have also seen, Miller. I must not dare to make a submission which your lordship have already taken note of. Now, what I did, I made a prayer before the district magistrate that kindly revisit the issue, and Miller, I should submit to my lords, Miller, at this stage, because this is the way, Miller, the chosen candidates are given the particular offer letters, and it is difficult, Miller, for interference, for the kind interference of this honorable court. Now, I made a prayer in the writ petition that my first prayer is for cancellation of the offer letter for dealership in favor of private respondent number 11. My second, that is the final prayer. At this stage, I am the last person, Milord, to place this thing. Now, the second prayer is that, Milord, a mandamus be issued to make an inquiry in respect of the candidature of private respondent number 11 as indicated in the complaint.
Your representation.
Yes, but no, I say, Milord, if your lordship disposes of the, they will get a greater strength, and they will reject and will reaffirm
their own stand. Therefore, what can be done, my lord? I was thinking this way, subject to what calls for my lord's kind consideration. Let these particular persons, my lord, that is the authority, be directed to file a report before this court about compliance of the formalities which are required to be adhered to. This is number one. And number two is that after they file a report, then the court will decide. And in the meantime, will an action taken that will abide by the result of the writ petition.
Very.
That no, I think no one will be prejudiced.
Might be.
But they cannot in any manner move in a hot haste manner, or Miller, they can disregard their own notifications.
The report is already here. Trying to be allowed to make submission of one copy. Lordship, the report itself is quite self-explanatory. All the grounds of their grievances, as I will point out to your Lordship, has been taken care of in this report itself. First thing, they were talking about the road, Lordship. If Lordship may come to.
No, that would be not proper. They have to give in a liberty to deal with the report also. So you have to place it with a affidavit. Okay, okay, okay.
They are talking about the road, Lordship. Page 4, it has categorically been dealt with. Page 4 of your report, your Lordship. Para 10, answer to para 10, where it says, it starts with the word denied. On the basis of complaint received from one applicant, Sana Khatur, regarding exercise of road as per map of L and LRO department, a memo was issued, previous such and such, dated 6/12/2024, the respondent number 11, to obtain authenticate documents regarding existence of road in plot number 85, Khotiyar number 597. She submitted the report of Revenue Inspector Damohana GP under PL and LRO Karamdiki, supply order and construction photo. As per report of Revenue Inspector Damohana GP under PL and LRO Karamdiki, it was found that there is a road which goes plot 87. So
85. Plot number 85.
Sorry, plot number 85, your Lordship.
Yes.
Annexure 8 has also provided your Lordship with pictures.
Report of inspector and pictures.
Correct. Great, good Lordship. So his complaint was gone, there's no road. That has been proved, your Lordship. There exists one. There was a complaint from the villagers, that has also been taken care of. Now his last complaint is that allegation is that the area of go down inquiry that has not been conducted fairly. If your Lordship would go to the very first page of the report, it shows what was the area of go down under the inquiry of Akbar Ali, who is the petitioner here, which is 517.14 square feet. And next page, page 2, Lordship. Area of go down of the respondent here, the private respondent, which is 631.62 square. So, Lordship, this report, as I said, is self-explanatory. Every process of selection has been explained with annexures given very clearly. I can always give a copy of this report.
No, why?
No, since Lordship was saying before you came. But Lordship, that will not serve any purpose because everything has been explained here clearly.
Yes.
This instruction is between Lordship and
Yes,
us.
yes. Very. Yes, private respondent.
So for the contention of the petition is concerned, contention speaks about two things. One, that I am not the resident of that particular village. The eligibility criteria doesn't say so. I have to be one of the individual who belongs from the Islampur subdivision. There is no question that I am.
That was not raised. That was never raised.
Second point raised is page 53. The answer to the RTI. Kindly come to page 53 for once. Now, my lord, kindly come to the para 3 of it. My lord, kindly see the second line. It covers the plot number 85 where my godown is situated. So, my lord, it is a admitted position in their RTI reply itself. My lord, it is said
That is your godown is at plot number 85.
85. So, my lord, it covers the second line and plot number 1682 and LR plot number 87 and 85.
Very.
Is a metal road. So, my lord, the RTI itself says the answer that in front of my godown there is road, metal road. Well, the 36 meters which is questioning, that is irrelevant for my purpose. Well, in front of my godown there is a road. So, my lord, that criteria goes. Now, my lord, for the sake of argument, if I say, my lord, there is some problem, I need some more manpower or I need to spend more money on that to carry the things to my godown. That cannot prejudice my learned client. That can be my headache at best. Though, my lord, I do not have that headache. But, my lord, that cannot prejudice.
Yes. That is not the issue. So, you want to deal with this report? Very. Please take down.
No interim order.
Subdivisional Controller, Food and Supply, Islampur issued a notification, issued a vacancy notification being memo number 343 dated 10th of May 2024 for new vacancy, new FPS dealership, vacancy of new FPS dealership at Mauja Gopalpur, Jogia, full stop. The present petitioner applied for the license. His proposed shop cum godown was inspected, and after compliance of all formalities, the concerned authority has selected private respondent number 11 to be the most suitable candidate. Full stop. The next part, the petitioner challenged the selection of private respondent on some grounds containing on the grounds that the concerned authority has selected private respondent number 7 to be the blue-eyed persons of the department, and other criteria regarding existence of road in front of respondent number 11, as well as the more spacious godown for smooth running of business, has not properly complied. It is the further contention of the petitioner that private respondent has no government road in front of his proposed shop cum godown, for which the individuals of the locality has made a complaint with the concerned department, which was not adhered to by the department. Thus, the incident petition has been filed challenging the selection of respondent number 11. Learned counsel appearing on behalf of the petitioner also submits that till the matter be decided, there may be an interim order so that the result of the instant date petition, so that the action of the authority may be abide by the result of the late petition. Full stop. Learned counsel appearing on behalf of the state authority has placed a detailed report. They have contradicted the grounds, each and every grounds alleged by the petitioner. I have perused the report. I have perused the copy of the report. It appears that the report contains all particulars regarding the regarding the justification of selection of respondent number 11. However, for the purpose of fair trial, the petitioner has to be given a liberty to contradict to deal with the report. Under the above observation, I find it would be justified to give the proper opportunity to the state respondent to submit the report in the form of affidavit. Within 2 weeks, report is ready.
Bulky one.
Okay, within 3 weeks, reply if any by the petitioner. Within 2 weeks thereafter. Good stuff. Let the matter 2 weeks thereafter. You want a date? Okay. Let the matter appear in the list.
My lord.
Okay, okay. Let the matter appear in the list. 20th of May. 20th of May. Another same heading.
Milord, in the meantime,
She's always there.
It is always there.
It's always there. Affidavit of service is filed on.
Our stands very clear.
It is always there. Affidavit of service filed on behalf of the petitioner is taken on record. 28th of May. 20th. 20.
Grateful, Lord.
Highly obliged.
Next.
Well, I am appealing for the state. Legalization of Andhra.
The vacancy of 2013. Page 32 is the vacancy declaration notice.
Two 2013 control order.
13 control.
No, 2020.
Page 32 the vacancy declaration notice.
What is page 30?
Vacancy declaration page 32.
13 control order.
13 control. The identical order first page notice is at page 174.
And what is your license?
License is at page, my lord, 30.
30.
Youth license, my lord. Page 4, paragraph 3, my specific statement, operational area.
Maharajpur Health Center.
Right.
Maharajpur.
Right. Yeah, Maharajpur.
Yes, so many.
Yes.
Critical order is at page, my lord, 174, passed by your lordship. The bench order is at page, my lord. I am playing the same order in terms of the order of the honorable division.
Yes, what is your submission?
My lord, may I ask question, my lord? Sometime or my lord.
No, regularly I am passing these orders.
The report, my lord.
No, you can file the report. No issue. Very well. Please take down. Very good. Present petitioner is running FPS business. Over area wherein the concerned SCFS has issued a fresh vacancy notification for appointment of FPS dealer. The present petitioner challenged the impugned vacancy notification for appointment of FPS dealer over the operational area, where the present petitioner is already running FP shop dealership business with full satisfaction since long.
Page 158. Of the Honorable Division Bench, paragraph 10.
Yes.
Page 158.
State respondent is directed to file a report in the form of affidavit within 4 weeks from date, exception thereto to be filed within 2 weeks thereafter. Considering the all submissions, the state authority may proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of the batch of appeals.
Paragraph 10 of the division bench, not to delink any as well. Since license is going, appointment letter has been issued.
As well, appointment letter issued.
Page 158. Offer letter has been issued in favor of the applicant. Page 158. I am paying order in terms of page 158.
158.
Division bench.
In terms of the division bench.
Division bench order. It starts from page 155. 158 is the operative portion, paragraph 10.
Okay. কি বললাম বলো? না তুমি এটা পুরোটা লিখতে পারবে না, তাহলে বলতে হবে তোমাকে। হ্যাঁ পুরোটা লিখতে পারবে না। 158 you say?
Paragraph 10.
Okay, okay.
We direct none of the.
Very well, very. কি বলেছি বলো তো? Full satisfaction since long বলেছি তো। মিস্টার পিঙ্গল ভট্টাচার্য, না ওটার আগে টাকা ওটা কাট। Mr. Pingal Bhattacharya, learned counsel appearing on behalf of the petitioner, submits that similar nature of writ petitions have been filed before this court, wherein this court has passed several orders directing the concerned state authority not to issue license till the disposal of batch of appeals pending before the honorable division bench, being MAT 1543 of 2024. Also, Mr. Bhattacharya further argued that in the instant matter, the license has already been issued.
So, offer letter has been issued, not like.
In this instant matter, the offer letter has already been issued in favor of the private respondent.
Applicant, I don't know who has, in whose favor has license, offer letter has been issued.
So you don't know?
No.
You not made party.
My lord, I also do not have any instruction, my lord. So, my lord, kindly, my lord, consider that in respect, my lord.
কি বললাম বলো? No, has already been issued, but it is not within his instruction who had received the offer letter.
Already license issued.
Full stop. It is the contention of the learned counsel for the. It is the contention of the Mr. Bhattacharya that the Honorable Division Bench in MAT 1543 has already been directed to the state as follows. The paragraph 10 of 158 page set out. 158.
And para 10 and 11, my lord. Kindly, my lord.
10 and 11.
Yes.
10 and 11. He submits that the same direction may be followed by the concerned authority in this matter. First stop. Learned counsel appearing on behalf of the state authority submits that he has no instruction about the matter.
As yet, my lord.
As yet. So it is not possible for him to enlighten the court regarding the fact whether any license has been issued or any ration card has been de-tagged.
Yes.
In this matter. Having heard the learned counsel for the parties, it appears to me that The similar matters are pending before the Honorable Division Bench in batch of appeals being MAT 1543 of 2024. Full stop. This court has passed several orders in past orders in several lead petitions following the directives of the Honorable Division Bench passed in following the directives of Honorable Division Bench passed in the batch of appeals in MAT 1543 of 2024 in terms of paragraph 8, paragraph 10 and 11 of the said order dated 6th of August 2024. However, in this matter, none of the petitioners or the state respondents are in a position to enlighten this court regarding the status of the FPS, status of the vacancy. At this juncture, I think it necessary to follow the directives of the Honorable Division Bench in this matter. Division Bench passed in Division Bench passed in MAT 1543 of 2024 by order dated 6th of August 2024. However, the state respondent is at liberty next month to file affidavit in opposition within 4 weeks, reply if any by the petitioner within 2 weeks thereafter. Considering the entire approach, there shall be an interim order in terms of the paragraph 10 and 11 of the order of the Honorable Division Bench passed in MAT 1543 of 2024 dated 6th of August 2024. Let the matter go out of the list. Parties are liberty to mention.
I only request you to I get this harbor copy of this matter today. So far, this matter is not. If you see harbor copy of this order, that begins.
Next.
Lordship, I'm paying for short passover, Lordship.
Passover means not today.
No, Lordship, kindly make it a short passover, Lordship.
I have a 12:30 matter, fixed matter. Before that, I have the
Lordship,
group 1 matter.
Lordship, fix it at 12, Lordship, kindly.
No, I cannot fix a date. No, cannot fix it. Yes, next. Yes. Item number 9 and 10.
Item number 9 will appear for the petitioner. 9 petitioner can I?
What is the matter?
Let's say, my lord, as item number 12, my lord. There also, my lord, there was no instruction, but Lordship has already passed an order. These are 2013 notification matters, my lord. Lordship will kindly take my license, my lord.
Yes, 10. Yes. 10 starts 10 first. Same matter. Yes. So you
7679, na?
where is your license?
7678. My lord, may I validate it? Since your Lordship will find at page 22, my lord. Praying for similar order, my lord, which your Lordship has passed. And my lord, similar order which your Lordship has passed in my lord, item number 12 today.
So praying for similar order.
It has taken it has without any order direction.
I have fixed one matter in this matter. When it was fixed, Monday.
21st.
Monday. Yes.
21st.
Come on Monday then.
No, that is one of the matters. My land friend is showing an order passed in one of the matters. I will show my lord orders passed in hundreds of the matters. my lord.
Yes.
Hundred of matters. My lord, what is maintainability, my lord? Well, my lord, then let my land friend, my lord, argue on maintainability, my lord, as to how this is not maintainable, my lord. Not we will, my lord. Let him argue today, my lord, because I am praying for an interim order, my lord. I am ready so far as maintainability is concerned, my lord. Let him argue on maintainability in that case. my lord. Lord, any day, my lord, my learned friend comes back, my lord. Any day, my learned friend comes back, my lord. I understand, my lord, but I am making my submission. My learned friend had interrupted, my lord. I was making submissions, my lord. Lordship, my lord, just now in item number 12, Lordship had passed in order, my lord. If Lordship had passed on the same date, my lord, Lordship passed in order, my lord, how can my lord, in respect of a similar matter, a different order be passed, my lord, in respect of, my lord, the same issue in question, my lord? Now, that will not amount to, my lord, judicial impropriety, my lord. in my
No,
humble
this
submission.
matter, the learned counsel appearing on behalf of the state not raise the point of maintainability. That's
Lord,
why
what
the
is
order has been
maintainability?
passed.
Let us now discuss, my
No,
lord.
no, see, he want to raise the point of maintainability, that is to be, he has to be heard. Otherwise, I cannot be disposed.
Let him be heard, my lord. Let him be heard
fixed-
today.
I fixed the similar matter on 21st, Monday.
It cannot be, my lord. If he's taken the point of maintainability, my lord, let him argue today, yes, sir. Because it's a point of maintainability.
Yes, he can argue today, but
Let him argue today, my lord.
he also want the date to be 1 day or 3 days.
This is perhaps not done, my lord. This perhaps this cannot be. Let us, my lord. Let us, my lord.
No, Mr.
Look
Huda,
at
I have
the
fixed
broader
some
picture.
matters on that date, you know.
Lordship, let us look at the broader picture, my lord. Say, for example, my lord, I challenge, my lord, the license given to a particular applicant, my lord, on 10 grounds. On 10 grounds, my lord. On 9 grounds, I fail. Say, for example, on 9 grounds, I fail, my lord. But on 1 ground, I succeed. What will be the fate of my application? The license would be cancelled. Because even on 1 ground, my lord, I have been successful. Similarly, my lord, here in this case or in these batch of writ petitions, my lord, I have taken several grounds. One of the ground is that, my lord, under the vacancy notices could not have been published under 2013.
Yes, that is the
Control Order 2013, my lord, because of, my lord, several reasons which your lordship has already heard. Now, on this issue, the division bench had heard and passed an order of stay. Passed an order of stay.
I know that you, Mr. Huda, you know.
Lord, let me learn 2 minutes. 2 minutes. Passed an order of stay. Now, my lord, my learned friend is not raising the issue with regard to maintainability, my lord, so far as, my lord, the issue that is before the division bench. He is raising a point of maintainability so far as, my lord, the challenge to the notifications are concerned. Now, my lord, in my very humble submission, my lord, may I say this? My lord, I will fail. I will fail in all the other challenges. But so far as, my lord, 2013 issue is concerned, my lord, my lord, because of the division bench order, where, my lord, they had, in fact, my lord, in appeal also, my lord, similar issue was taken up. And the appeal court said that whatever order the learned single judge has passed is a valid order, because otherwise this will amount to my lord, amount to multiplicity of judicial proceedings. So if an order is passed in respect of all the other matters also where a stay has been granted, then in that case, the judge has done the right thing. Lord, I am, Lord, on the same issue, Lord, today I am saying, Lord, I am taking it on face value that I will fail on all the other grounds. Because point of maintainability is not in respect of all the other grounds. Maintainability, my lord, he is taking the ground of, my lord, the challenge to the notifications. My lord, if I do not place today, if I do not place, my lord, my challenge to the notification, my lord, even then I will succeed because of the order of the division bench. Now, my lord, my lord, lordship sitting in single bench, my lord, has to abide, my lord, by the orders passed by the division bench, my lord. Division bench has taken note of this.
had taken specific note of this fact that, my lord, the order passed by the learned single judge is absolutely correct because this will otherwise amount to, my lord, multiplicity of judicial proceedings, my lord. And now, my lord, maintainability. What is maintainability, my lord? Maintainability is, my lord, if my writ petition is not maintainable. Why? Either, my lord, this court does not have jurisdiction, my lord, the case pertains to Bihar.
Maintainability, you cannot argue. He has argued the maintenance.
No, my lord, this is
Mr. Huda, I know your contention is.
Well,
Your-
this
your
challenge,
contention-
no, Lordship, this challenge with regard to the notification is not a challenge of maintainability. This has to be understood. This is a challenge on merits. That whether their notification was-
their contention before this court that you cannot challenge. You cannot
which
challenge
ground?
that. Let them argue on that point. You cannot
My
challenge.
friend said, my learned friend
Cannot challenge the notification itself. This is their ground.
Yes,
Which
my lord.
they argued, it was not placed before the learned division bench. This is the new matter.
No,
That's why I
Lordship,
fixed.
my lord,
I
perhaps, my lord,
fixed the matter to be argued first.
perhaps, my lord, I could, my lord, may I, my lord, once again try, my lord. Perhaps, my lord, I could not, I was not, my lord, very, my lord, lucid in my explanation, my lord. This, my lord, in this petition, my lord, I have taken several grounds. Here, the issue is with regard to only two grounds.
Now, let you discuss the matter one after another. Let me understand your submission
Yes,
first.
yes, yes,
And my appreciation of your understanding.
yes, yes, yes.
You argued that you have filed the writ petition on several grounds, challenge the selection of a private respondent.
No, 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 no.
Challenge the notification.
Notification.
So you challenge the notifications, challenging the vices of control order 2013, whether it is applicable or not. Okay, that is the only ground. They say, as far as their submission, they say you cannot challenge this. This is their prayer is you cannot challenge this even. Whatever may be their submission or like that, I have not heard it at all. They say you cannot challenge this.
I cannot, they say that I cannot,
Yes,
they say that I cannot challenge
you
that.
cannot challenge this.
This word, they say, but
So this is so far I understand their submission. They said you cannot challenge in writ petition that the control order has no existence or like that. And this matter has
Well,
not
that is-
appeared
that
before
is-
the division bench.
And the division bench has passed an order of
No, this matter was not before the division bench itself.
well, the issue before the division bench is whether these notifications could have been published under 2013 control order or not. That is it.
Yes, they say this issue you cannot challenge
Huh?
in a writ petition. This is their only contention.
My lord, may I, my lord, since your lordship has, my lord, given me time, my lord, to appreciate my lord, submission, my lord,
Yes,
let us forget about, my lord, all the other grounds.
I understand your
Lordship
submission.
will kindly allow me, my lord, 2 minutes, 2 minutes. Let us forget about all the other grounds, my lord. Let us only concentrate on two grounds. One, I say that the several notifications, my lord, by which, my lord, the principal secretary and the director, my lord, had passed orders of, my lord, de-tagging the ration cards, my lord, is under challenge. That is one of the ground,
Yes,
which is not before the division bench. This issue is not before the division bench.
yes,
That's one of the ground. The second ground is, out of several grounds, the second ground is that a vacancy notice under 2013 control order could not have been published because of, my lord, the NFSA 2015 coming into existence, my lord. So, my lord, this issue is before the division bench. The division bench, my lord, after considering the entire gamut of the case, my lord, has passed an order saying that no, this issue is a valid issue and it has to be decided till such time an order was passed, my lord, where, my lord, the department, my lord, was restrained from de-tagging. So, my lord, out of the two issues, my lord, one issue before the division bench. Now, my lord, today I stand before your lordship saying that let us forget about all the other issues. First issue, my lord, about the my lord, the notifications, my lord, I say, my lord, for the purpose of interim order, I am not even pressing that. The only issue that I am pressing is that vacancy notice under 2013 could not have been published. For which, my lord, I have a valid argument that the division bench has appreciated this argument, and therefore the division bench has passed an order of status quo, my lord, or passed an order restraining, my lord, detagging. So today, for the purpose of interim order, my lord, I am only on one of the grounds. Only on one of the grounds. They say that no, I am challenging maintainability. They say they are challenging maintainability. What is their challenge? They say that I cannot challenge those notifications. What notification? Ground one. But I am today saying that I'm not even pressing for it. I need not. Out of 10 grounds, even if on one ground I'm successful, which I am before the division bench, I need not press the other issues. So, my only thing is that because of the order of the division bench and because I am only and only on the ground of validity of the vacancy notice, on the ground of that being published under 2013 notification, that is my only ground today.
Very well.
But so far as maintainability is concerned, the fundamental point, the fundamental jurisprudence of law is, maintainability is when it is not about challenging a notification and that notification not being maintainable. That's on merit. That is not maintainability. Maintainability is, say
No,
for
Mr.
example,
Huda, you cannot argue on maintainability. They have
since
to
you are
argue.
saying, since you are saying maintainability.
Yes, they have to argue on.
Yes,
point of
what I'm saying
maintainability.
is that what you are arguing is not about maintainability. It is on merits.
Very well,
Merits
very
is completely
well.
different from maintainability.
Okay.
But I am today only pressing on one ground.
Very
Now, your lordship will pass an order whether I am entitled to an order of stay only on this ground or not. But that's it. That is it. Because I already have an order from the division bench. That is it.
Yes, Mr. Chairman.
Kindly record my submission and whatever lordship orders, lordship may pass me on.
I can come back tomorrow with question. 2022 notification that has been challenged, that I am entitled to file an opposition without even an interim order. I did not pay for that.
Well, I can show 10 judgments where your lordship had passed order in respect of 2022 notification. 10 notices, my lord.
Two of them, where your lordship has not granted any interim order. I have appeared and insisted the honorable court, and your lordship has refused to pass the interim order and rejected filing of it. I'm even not paying for that. I'll pay the judgments of the honorable division bench. Allow me to come back and report here.
Very well.
I'm praying for an interim order, my lord.
Yes.
Lordship will kindly pass a reasoned order.
9 and 10, same issues.
Same
issues.
Same 2013 notification, my lord.
Please
Same as in item number 12, where your lordship has today passed an order of state, my lord, interim order.
May have other coming.
And I'm praying, my lord, similar order as in item number 12.
Petitioner is running a FPS business over the operational area, over a operational area wherein the concerned SCFS has issued a, where is the notification? Issued a vacancy notification for appointment of new FPS dealer following the provisions of WBPDS Maintenance and Control Order 2013. Full stop. Next by Mr. Huda, Learned Counsel, appearing on behalf of the petitioner, submits that same and identical issues are raised before the Honorable Division Bench in a batch of writ petitions in MAT 1543 of 2024, wherein the Honorable Division Bench in an order dated 6th of August 2024, VD paragraph 10 and 11 has passed a specific direction upon the concerned authority as follows. Full stop. He submits that The present petitioner is running the FPS in an unblemished manner, so he deserves the similar interim order. In terms of the division bench, in terms of the order of the Honorable Division Bench. Full stop. Learned counsel appearing on behalf of the state authority raised strong objection and submits that the instant writ petition is not maintainable. Full stop. He submits that the present petitioner, being a licensee, cannot challenge the decision of the state authority in respect of detagging of ration card holders from a dealer. He submits that the issue for maintainability of the writ petition is not before the Honorable Division Bench. So, in this matter, no interim order can be passed without giving the appropriate hearing of the maintainability to the state authority. First of having heard the learned counsel for the party.
May I, my lord, very interrupt, my lord, this issue, my lord, which your lordship has just dictated, my lord, it was before the single bench, my lord, and single bench, my lord, decided in favor of the writ petitioner.
Okay.
This particular, my lord, what your lordship, my lord, whether I can, my lord, having a license under 2013, whether I can challenge 2013.
Yes, that is the only issue there.
Yes.
কি বললাম? Having heard the cutoff, next particular, Mr. Huda, learned counsel appearing over the petitioner submits that this issue has already been decided by this court in other matters. Having heard the learned counsel for the parties, it appears that the state authority has raised the point of maintainability. I find that there are some other writ petitions which are fixed for hearing on the point of maintainability on the same issues. Full stop. Accordingly, thus this matter be fixed on 21st of April 2024 for further hearing. Full stop. Having heard the learned counsel for the parties and considering the materials on record, I think it justified till the issue be decided regarding whether the instant writ petition is maintainable or not. The state authority must follow the directives of the Honorable Division Bench passed in MAT 1543 of 2024 under order dated 6th of August 2024 in paragraph 10 and 11. Paragraph 10 and 11 as stated herein above.
Obliged, deeply obliged.
Full stop. Let the matter appear in the list on 21st.
Lord, may I, Lord, very humbly pray, my lord, 21st, I'm nominal. I'll be in Supreme Court, my lord. Kindly, my lord, fix it on 22nd, my lord.
Let them argue on that point. Thereafter, I will fix the matter on 22nd.
Yes, my lord, my juniors would be here, they would take notes.
Sir, we fix the.
But I have, my lord, informed the lordship beforehand that 21st I will not be in Calcutta, my lord.
They have fixed the matter. No, those matters are fixed 21st. That's why I want.
One matter, not those, only one matter.
One matter, I think two matters are there.
Only one matter, my lord. My matter, only one matter.
Not your matter. Another matter is there also, I think.
If for other petition, I do
Yes,
not.
other petitioners there are some matters.
No, that is on a different issue, my lord. That, my lord, Mr. Agarwal's matter, right?
I do not know.
Yes, Mr. Agarwal's matter. Well, that's on a completely different issue where Mr. Agarwal is saying that so far as the notification of the principal secretary is concerned, he is saying that relying upon that notification, my cards cannot be detagged. That's a different issue.
Okay, let it fixed on 21st. Let them argue first. If
But
you
Lord,
are
will kindly
there,
not pass
I will-
any.
No, I will not pass anyone.
22nd, I'll come and argue.
Yes.
I knew they would take the point of I was ready today for maintainability. This is not
No,
maintainability.
let them start.
This is absolutely on merits.
I know that.
Anything and everything cannot be maintainable. It's a completely
Monday.
different issue.
I know that.
Obliged, obliged.
They have to take chance, Mr. Huda. Yes.
But say, my lord, fighting
They have to
on
give
merits,
the opportunity to argue on that point.
saying maintainability, my lord, is that that is I knew that I had brought judgment as to what is maintainability. Obliged.
Item number 13 was placed for passover lordship Item number 13 of today's list, Lordship.
Yes.
I beg to appear on behalf of the petitioner, Lordship. Lordship,
Have you served?
yes, Lordship.
I'm very sorry to interrupt, but I forgot to congratulate you, Lordship.
Okay, thank you, thank you.
Happy, completely missed. Okay.
Lordship, my matter is very simple, Lordship. I have relied upon the document which has been annexed, Lordship. Lordship will find for page number 35. Lordship, so far the license is concerned, Lordship, that was earlier issued in favor of the husband of the present petitioner. During the tenure of his license, Lordship, he passed away. I have annexed the document, Lordship, at page number 37 that the particular person died on, Lordship, that was on.
What is the name?
Lordship, the name of the person was, name of the disease, Lordship, was, has been mentioned. I have mentioned in my petition, Lordship, that is Aminur Bewa. Now, Lordship, so far the now Farhad Munim. Now, Lordship, then after this person passed away and the license and the beneficiary list has been tagged to the nearest dealer when that person passed away. Now, subsequently, Lordship, that the renewal of the license has been given to the wife. Wife got the fresh license, Lordship, that I have annexed, Lordship, will find for page number 36.
Yes.
That the new license has been issued in favor of the wife of the deceased person. He is the petitioner hearing.
Very well.
Now, Lordship, at the time of that transfer, at the time of the license was terminated due to the date of the person and the beneficiary list has been tagged to the nearest dealer. On that situation, Lordship, that the quantity of the essential commodities retained in the possession of the person, Lordship, that has been measured and then after it was tagged to the nearest dealer. I don't raise any objection to that effect. Now, subsequently, Lordship, in the meantime, no new license has been issued in favor of the petitioner. Now, Lordship, what happened? There is one notification has been issued. Your Lordship will come to page number 40. Your Lordship will find that is Annexure P3. That one notification has been issued by the Government of West Bengal Department of Food Supplies. Lordship, it was signed by the Subdivisional Controller Malda. What has been stated in the notification, Lordship, that was issued on 29th of April 2024. And the contention of the notice is very simple, Lordship, that it has been observed that the following the demise of Farhad Munim, license number such and such, you were appointed as a FCS dealer on compassionate ground. The system indicates that the EPOS food grains closing balance from Farid Momin's account has not yet been incorporated into your online portal balance, despite you retaining the physical stocks. Despite provide previous request to sign the matter, now, Lordship, there is no whispering of the previous request, Lordship. I am only with the document, Lordship, the state will be the better position to submit whether the previous request has been made or not. I am only with that document, Lordship. Despite previous request to sign the merger certificate or provide details of any incurrences in the portal figures, no submission has been received from your end. This serves as a final request to you to submit a written declaration detailing any such and such you may have noticed. In the absence of any discrepancies, your signature on the returned merger certificate would be appreciated. Should no response to receive with 7 days, it will be understand that you agree and the stock merger will proceed with the portal. Now, Lordship, the entire situation has been started from this notification. Now, I received this notification, Lordship. I do not know what to reply on that ground, Lordship. And subsequently, they has been stated in their notification that if in the meantime you are not replying with the discrepancies, if any at all take place, then it will be continued. Now, Lordship, that the period when the person was died, my beneficiary list tagged to the other person, that has been taken place. The remain stock has been attached with the persons who are taking care of the beneficiary list, and subsequently compassionate appointment has been given to me. So in entire scenario, I am nowhere. Now, Lordship, subsequently what happened, Lordship, we will find from page number 42 that on 11th of February 2025, they have issued a notification, show cause notice. Now, what is the ground of the show cause notice, Lordship? Whether it appears that you did not participate in the Duare Ration scheme in February 2025 until 11th February 2025. On 11th, this notice has been issued. And what is mentioned in the notice that it appears that you did not participate in the Duare Ration scheme in February 2000 until 11th February 2025. And on that day when the notice was issued, signed by the authority, they are indicating that particular date also. Where the irregularities has been adopted by the state lordship, I am just emphasizing on that point, lordship. Whether it appears that you have acted against the provision laid down in such and such by not participating in the Duare Ration scheme, whether it appears that in the violation of the clause such and such of the order, now therefore the FPS are hereby directed by the undersigned to exercise his power conferred upon him under clause 45 of such and such to show cause that why penal action shall not be taken against you. Now that is the contention of the notification. Now lordship, kindly come to page number 43, lordship. That is annexure P5, lordship. Now further they have notified with another so cause notice, lordship. Why am I indicating, lordship? That if one so cause notice has been issued, so far the procedure is concerned, I have to give reply as per their so cause notice, and then after they will give an opportunity of hearing, and I have to say in my support, and then after, lordship, after consideration and upon writing the entire proceeding, lordship, they will pass an order, reasoned order, lordship. That is the procedure that has been laid down in the control order 2024. So far this notification is concerned, lordship, it is laid down under the control order 2024 and followed by the control order 2024 that has been notice has been issued. Now what written in that part, second so cause notice, lordship, now they have come with a further complaint, lordship. On 11th, they have come up with a point that I have not performed as per the Duare Ration scheme. On the very next day, they have further issued another notification, lordship. Now with a new point, lordship, that as complaint received from Prakash Pramanik, that has not been attached. That one individual may lodge the complaint, lordship. Whether there is any validity, whether there is any sanctionity of the complaint or not, I am not going to the merit of that complaint, lordship. So far the notification is concerned, I am on that, lordship. What has been stated in the notification, so cause notice, lordship, that whereas the FPS dealer issued EPOS slip or making false entry in EPOS, lordship, at a place away from FPS but distributed and delivered to the PDS commodities from the FPS not in the para mohalla of the assigned cluster of the day since 8 months. Since 8 months, there is a mistake, lordship, in typographical error by the state lordship. 8 months. Now, I individual is complaining that for the last 5 months, I am not performing, lordship. Whether he in a better position to ask for that, may lodge a complaint that last 8 months I am not performing or not, lordship, that is question. I may put this question, lordship. Now, what happened that in earlier occasion, there is another so cause notice, and second time there is another so cause notice. Now, kindly come to page number 46, lordship. That the hearing notice has been issued. Now, in the hearing notice, that as reply on such and such submitted by such and such in response to the file memo number such and such dated is found unsatisfactory. No hearing has been conducted. I have given the reply, and upon the reply, they have said that my reply is unsatisfactory, and therefore it was issued on 20th, and on 21st they have asked for a personal hearing at 4 PM, lordship, positively. Now, lordship, kindly come that I have present in the hearing. Now, they have issued a suspension order on 10th of March 2025. Lordship, kindly consider the suspension order. Whether as per the report of inspection conducted, now, lordship, they have suppressed the entire documentation. They have issued a notification for the personal hearing. They have so-caused me on a particular ground. Now they are issuing a suspension order in a different footings, lordship. Kindly consider, lordship, what have been stated in on 10th March 2025. They have issued a suspension order. Whereas as per the report of the inspection conducted on 4th March 2025 by the inquiry team led by such and such Chief Inspector of English Bazar in response to the various public grievances. Now it's saying that various public grievances. Now, so far the earlier so-called notice is concerned, lordship, there is no whisper of that. There is any complaint, grievance complaint has been lodged against me. That one person has made a complaint that has been mentioned in the so-called notice. Now they are come up with several that various public grievances are there. It has appeared that you are acting against the interest of the beneficiaries tagged with your FPS and hampering the smooth functioning implementation of the public distribution system. Accordingly, as per the inquiry report, physical stock at your FPS could not be assessed as you have not attended and opened the FPS even after instruction over telephone. Now, Lordship, they come with a vague allegation, Lordship. They have instructed me over telephone. Now they have issued the suspension order. Now, Lordship, so far the rule is concerned, they have to issue the notification, so-called notice. I have to reply, there must be a personal hearing should be conducted by the authority. They have not conducted, Lordship. Now they issued a suspension order on which, Lordship, on a date mentioned by them, they have come and they have issued the suspension order. Without whispering, without given an opportunity of hearing, without given a so-called notice to that effect that on 4th, if I, for the sake of argument, Lordship, I admitting that I was not available on that day to cooperate with them, Lordship. That what remains, Lordship, they have to issue a so-called notice that why I am not cooperating with them. And upon that so-called notice, they have to conduct a personal hearing. Then after only can the suspension order can be sustained, Lordship. Otherwise, it cannot be without following the due process of law. They cannot issue the suspension notice. Now, Lordship, kindly come to the next page, Lordship. On 24th of March, they have issued another notice, Lordship. Direction to comply with the suspension order. Now, where I am challenging a suspension order, to that effect, Lordship, they have issued a direction to comply with the suspension order, Lordship. And I have, in my writ application, I am challenging these two notifications, Lordship, two memos, which has been issued by the subdivisional controller, that whether it is sustainable in the eye of law or not, that has to be determined, Lordship. Now, Lordship, during this pendency of the writ application, when I have filed the writ application, they have further issued a notice, Lordship. I have not prepared the supplementary list, Lordship. It's reached to me right day after yesterday, Lordship. So I am unable to prepare supplementary affidavit, Lordship. May I just hand over, and your Lordship is direct me to file with a supplementary, I will come, Lordship. Kindly consider the document, Lordship, at once, Lordship. That on 9th of April, Lordship, what they have stated, Lordship, it was attached to my shop room, show cause and personal hearing notice, Lordship. Now, what kinds of foul play has been taken place in the part of the subdivisional controller, Lordship? That one, they are issuing a show cause notice. Further, they come up with a new point and issued a hearing notice, issued a further show cause notice. Now they have issued a suspension order in connection with another inspection has been conducted by them. That is no way connected with this show cause notice has been served upon me, Lordship. Now, Lordship, at this juncture, after the suspension order, they have come up with a further show cause and personal hearing notice. May I indicate, Lordship, the control order 45, Lordship, that what is the procedure should be maintained, what is the procedure should be followed by the subdivisional controller before taking all these kinds of drastic foods, Lordship, against a person whose bread and butter is depends upon this FCS license, Lordship. I have suffered, I have come with a long way, Lordship, that I suffered. My husband was tired. The license was issued in his favor, Lordship. Subsequently, it was tagged, and I have to wait till 3 years to get the new license, Lordship. I got the new license without given an opportunity or without any steps taken by the concerned authority, Lordship, to that how much essential commodities are remain in my stock and what will be it should be followed in accordance with law, and then after it should be attached with my EPOS machine. That has not been followed. No opportunity has been given. It was admitted by their notification. It has automatically admitted.
So what is your prayer now?
My prayer is for the set asiding of the two notice, Lordship. That is in Annexure P8 and P9, Lordship.
Where you come with the supplementary?
And this and in the meantime, some protection may be given.
No,
that
no protection.
No coercive steps should be taken against me, Lordship.
Already they have taken coercive steps against you. What you want?
That is under challenge, Lordship. I have challenged that notification, Lordship.
What is the status of FPS now?
Now, Lordship, so far the
all
notification
detagged.
is concerned, I cannot perform. I cannot perform.
Yes,
Lordship, so far
all detagged now. What can I done without
no,
hearing?
Lordship, it has not been tagged. It was not been tagged, Lordship. That is their contention.
Okay, you come with the supplementary Monday. I'll pass the order.
And in the meantime, Lordship, some protection, Lordship. No coercive steps already, Lordship. They are asking for the FPS machine, Lordship. If the fate of the cases comes in favor of me, Lordship, only that protection I am required, Lordship.
What protection? That
in the meantime, no steps should be taken for the.
They have already taken. You suspended you.
Lordship, and that is under challenge, Lordship.
Yes.
I can satisfy your Lordship that the entire suspension is absolutely illegal, Lordship.
Okay, come with that.
So far the order is concerned, Lordship, I have indicated all the documents and all the points, Lordship. How can they suspend by?
Where is your reply? You have not placed your reply.
Lordship,
You have why you not answered them?
I have answered, Lordship. I was present.
No, you have not answered at page 40. What is your answer? They have time and again asked you to.
Lordship, that is the so-called notice, Lordship. Page 40
No,
is
what
the
is the
Lordship.
all so-called notice regarding the stock measure?
Lordship.
Everything is there. You are not using EPOS.
Page
Everything
40
is there. Complaint is
40
there.
Yes, Lordship. Page 40 is the stock margin. I have
So
not
why
replied.
why you not deal with the stock?
Now, Lordship, if
No, the answer is why you have not dealt.
Lordship, that is a valid question, Lordship. But
Then-
so far this notice is concerned, Lordship, I have not replied you. I can very candid before your Lordship, I can submit, Lordship, that so far this.
You come with
29th
supplementary. I will pass
Lordship,
the order.
but Lordship, that so far the so-called notice is concerned, Lordship, that has not been followed the procedure, Lordship.
Very.
Why I am on that point, Lordship? So far the so-called notice is concerned, it is not followed with the in accordance with law, Lordship. Sir, whether it can sustain, Lordship, that on 11 they have issued a so-called notice on a particular point. On 12 they come with another point, and on 30th, Lordship, on 10th of March, Lordship, they have suspended with another point, Lordship. Your Lordship will find the suspension order. There is no whispering of the so-called notice and the answer to the so-called, Lordship. Kindly consider on that point, Lordship. Only consider that point.
Very.
That what has been stated on 10th of for my satisfaction, Lord, kindly come to page 46 at once, Lordship. I will only draw your Lordship answer on 2 lines, Lordship. Whether as per the report of inspection conducted on 4th of March 2025. In earlier occasion, Lordship, the so-called notice is on another point. But so far the point on 10th March, this notice has been issued, Lordship. They have stated that they have conducted inspection. I was not there. So that's why they have suspended, Lordship. I am only that point, Lordship. Whether I am eligible to get an opportunity of hearing or not, that should be determined by this writ code, Lordship.
Very. Please take down. Read petitioner is a widow of erstwhile MR dealer, namely Farat Momin, Farat Momin. After demise of her husband, the license was issued in her favor. Full stop. It is the contention of the petitioner that state authority has issued a so-called notice in favor of the petitioner on 11th February 2025 and again on 12th February 2025 on several grounds. The petitioner replied to the so-called and he was given an opportunity of hearing on 21st of February 2025. He appeared in the hearing before the authority concerned. Subsequently, on 10th of March 2025, one suspension order was passed by the concerned authority, which contains some other grounds for issuance of such suspension order. Learned counsel for the petitioner submits that the grounds for suspension of the petitioner as embodied in the order dated 10th of March 2025 was not properly communicated to the petitioner through a proper so-called notice. He further submits that further memo dated 24th of March 2025 was issued by the concerned subdivision controller regarding direction to comply with the suspension order. He further submits that after the order of suspension, again a fresh so-called notice was issued in favor of the upon the petitioner on April
9th of April.
April 9th, 2025. Full stop. He submits that the act and action of the
They are also the inspection.
act and action of the concerned authority is beyond the provisions of law. So the suspension order dated 10th of March 2025 as well as 24th of March 2025 requires to be stayed. Full stop. Affidavit of service filed on behalf of the petitioner is taken on record. Despite service, none appears on behalf of the state authority. Full stop. Having heard the learned counsel for the petitioner, considering the facts herein, it appears to me that the concerned authority has issued suspension order on 10th of March 2025 containing the grounds which not improper similar to that of the so-called notice issued to the petitioners on 11th of February 2025 and 12th of February 2025. However, justification for issuance of the suspension order can only be assessed after hearing both the parties in detail, considering the entire facts and circumstances. I think it necessary. Interim order in this matter shall automatically dispose of the merit of this matter. Thus, I restrain myself to issue any interim order in that matter. However, the petitioner is at leave to file supplementary affidavit in respect of the documents of further suspension order, further show cause notice, hearing to show cause notice
In a personal hearing.
within a week. Let the matter appear in the list on April 28, 2025.
If it be possible, Lordship, can it be on Monday, Lordship? I will further issue a notice and along with the supplementary agreement. Because there are certain
This Monday,
by this Monday, Lordship.
this one 21st, I have several matters.
Lordship, it will take 2 or 5 minutes to
I know that. Come on then 23rd,
23rd. On 23rd.
6 on 23rd.
That would be
The petitioner is to serve notice upon the state regarding supplementary affidavit. Next.
Number 14, my lord. In this matter, my lord, Mr. Ashim Kumar Rao is appearing for the petitioner. My lord, he is out of station due to his medical checkup, my lord. Kindly make the matter not this week, my lord, so that the matter can appear on the next Wednesday.
Who is for the state?
Mr. Shondi Charan, there is
Very well, not this week.
grateful.
Next. First call.
Your Lordship, I'm in this matter for the respondent, West Bengal Power Development Corporation.
This matter, my lord. For the
Take your mic properly. Yes, which for the petitioner?
I'm for the petitioner. My lord, in this matter, my lord, for the purpose of my lord construction of the Bokresha thermal power plant, my lord, land of several people was acquired, including the land of the petitioner, my lord. My lord, the acquisition was made, my lord, on the condition that one of the member from the landlord's family will be given one employment in the Bokresha thermal power plant. And after this my lord, promise was made, 2 notification was published.
What is the number of this case? Item number 20?
17.
17. Item number 17?
17.
Okay.
Right, for the purpose of construction of the Bokresha thermal power plant, the land of several people was acquired, including the land of the petitioner. The acquisition was made, my lord, on the condition that one of the member of the landlord's family will be given one employment in the Bokresha thermal power plant.
But in terms of the promise, my lord, two notifications were published in the year 1996 and 1998. Lordship kindly comes to the notification, page number 25.
But that there is no particulars in the land. Petitioner no mention anywhere in the respect of their, how they are
Let me
relating
make
this
my
land.
submission, then my lord, learned counsel can mail. Your lordship
No,
kindly comes to page
they have acquired your land.
They have acquired my land.
So what land they want to know the number.
Acquisition was made, my lord. Acquisition was made, but subject to the condition that one of the member.
No, I understand that.
That is
So what land? What they want to know? What land?
This was, my lord, agricultural and homestead land.
No, number of the land. Number of the land. Whether you have mentioned it anywhere in your writ petition?
Nothing. No mentioning any where.
Right, even if the land dark number is not mentioned, but my lord, in terms of that notification, certificate has been issued to me.
Where is the certificate?
Lordship kindly comes to the certificate, page number 73.
73. 73.
Certificate has been issued under the exempted category, and this is the, my lord, in terms of the 2002 notification, the certificate, my lord, indicates that I fall under the exempted category. There are 4 writ petitioners, my lord, and certificate has been issued against all the 4 writ petitioners.
Exempted category.
Your lordship kindly comes to the 2002 notification at page number 27, my lord. This particular certificate was issued in terms of the 2002 notification in favor of the petitioners, my lord. Lordship kindly comes to page number 27.
Page number 27.
27. In exercise of the power conferred by subsection A of section 3 of the West Bengal Regulation of Recruitment in the State Government Establishment and Establishment of Public Undertakings, Statutory Bodies, Government Companies, Local Authorities Act, the Governor is pleased to declare the following categories of person as exempted categories for the purpose of the aforesaid Act. My lord, in terms of this notification, my lord, your lordship kindly comes to subclause 3. People belonging to the families of land losers. Candidate belonging to the land losers family were placed under the exempted category. Lordship kindly comes to the next page. Lordship kindly comes to the next page. At the very bottom one.
Yes.
The lordship will see by promotion or by absolution of person declared surplus by the state government or by absolution of such categories of casual workers and other workers by the state government may by notification specify from title as reserved to be filled up by the person within the exempted category. So 30%, my lord, reservation was given to the person belonging to the exempted category. And in terms of this notification, my lord, the exempted category certificate has already been issued to the petitioners. Apart from that, my lord, if your lordship kindly comes to page number 26 once.
No, you read paragraph 3. That is the page 27.
Candidates, persons
belonging to the families of land losers.
Candidates hailing from families who might have been uprooted from their place of residence due to acquisition of homestead land by the government, or whose main source of income is substantially affected due to the loss of agricultural land as a result of the land in question being acquired by the government for the public purpose, shall be covered in this category. So, my lord, my land was acquired when the Bokreshwar thermal power project was established. At that
So
time,
where is your land?
in terms of this notification, my lord, land loser certificate under the exempted category has been issued to me. Your lordship kindly comes to
Only one member of the family can be given this chance.
only one member, my lord.
Then
Only one member. The four
land loser certificate may be issued all the family members, but one member is entitled to get the certificate.
I am claiming that only one member of the family from the petitioner may be given an appointment. Your lordship kindly comes to page number 26 once.
Page number 26.
Lordship will see this is the notification 1998. In terms of this notification, my lord, a committee was supposed to be formed, and that committee was supposed to, my lord, prepare the list of those candidates who belong to the land losers category. And accordingly, the names will be forwarded to the WBPDCL for the purpose of giving employment to one of the members from the land losers category. Your lordship kindly sees the notification. Governor is pleased to reconstitute for a period of 2 years from the date of issue of this notification a local land advisory committee for the Bokreshwar Thermal Power Project of West Bengal Power Development Corporation Limited, hereinafter referred to as the said committee. These are the members of the said committee, my lord. The said committee will help the West Bengal Power Development Corporation Limited in preparation and finalization of priority list of the families affected due to the acquisition of land for Bokreshwar Thermal Power Project for employment of one members of each family under the WBPTCL within the framework of the concerned government order concerning appointment of land losers in the power station. Therefore, my lord, in terms of this notification, my lord, one member of the affected family was supposed to be given one employment in the Bokreshwar Thermal Power Project. Now, subsequently, in terms of the 2002 notification, my lord, the government declared the person belonging to the land losers category as an exempted category. Now, 30% reservation has already been given to the person belonging to the exempted category. And in terms of the 2002 notification, already a certificate has been issued under the exempted category to the petitioners. That is at page number 73, my lord. Thereafter, my lord, the district magistrate, in terms of the earlier notification, has already, my lord, referred the names of the petitioner to the WBPDCL. In the year,
the list.
The lordship kindly comes. That is at page number 78, my lord. By this letter, my lord, the district magistrate has already sent the list of those candidates who belong to the exempted.
What is this 78?
78, lordship will see Sanjoy Roy and 20 others. I fall under that category.
Sanjoy Roy is the petitioner here?
No. Petitioners fall under the Sanjoy Roy and 20 others. Lordship will see page number 78.
All the petitioners.
There are four petitioners. There are 4 petitioners. I fall under the second list, my lord. Sanjoy Roy and 20 others.
In reference to your application, you request to submit attested copy of employment exchange card enclosed for example.
Accordingly, my lord, district magistrate has already forwarded the names of the people belonging to the exempted category to the West Bengal Power Corporation Limited, my lord. They are now, my lord, supposed to give the employment to the petitioners. Now, my lord, for the past 25 years, my lord, the petitioner is running from pillar to post, my lord, for getting employment, my lord. And my lord,
what you have done in respect of that memo of the district magistrate? Have you placed your documents?
Already, my lord, the documents have been forwarded by the district magistrate to the my lord, concerned West Bengal Power Development Corporation Limited.
So when you submitted your documents?
My lord, my documents, your lordship kindly comes to the next page number 79.
To the manager.
To the manager, Bokreshwar Thermal Power Project. Enclosed, please find here the original application of Sanjoy Roy and others, along with enclosures which will speak for already, my lord, the documents that which certify that I belong to the exempted category has already been, my lord, sent to the manager of the West Bengal Thermal Power Project Limited. Now, my lord, it is for, my lord, them, my lord, to give employment to one of the members of the affected families of the petition. Already, my lord, the district magistrate has already forwarded the names. Now, my lord, notification is of the year 1998.
Already, my lord, 27 years has passed. My lord, petitioner has made several representations before the concerned authority. Till date, my lord, no steps are being taken, my lord.
No, what do you mean by exempted category? Only for land losers?
No, exempted category, my lord, land losers were one of the subsets of the exempted category.
So why, how can you say that you are the land losers?
Your lordship kindly
That's why
sees
you
the
are the exempted category?
exempted category certificate.
'72,
73, my lord.
'73.
Your lordship kindly comes to page number 71, my lord. Page number 70.
Page number 70.
70.
Yes.
In terms of the notification dated in terms of the 1998 notification, my lord, the selection committee, your lordship will see, the selection committee comprising of the undersigned, WBACTCL, WBACB and WBPDCL. On the day interviewed 182 candidates, 18 found absent for absolving their suitability as regards to the suitability as regards to the mallet, it is not eligible. Academic qualifications as also physical appearance and intelligible level of 95 candidates have been found suitable. Now your lordship will see the list of candidates in page number 71, my lord.
Yes.
The petitioner number 4 in this petition, my lord, is serial number 128. Narayan
Serial
Kumar,
number 128.
serial number 128. Your lordship will kindly comes to page number 71. Priority serial list, serial number 128. Narayan Kumar Chaudhary is the petitioner number 4.
I
before
don't
your
have
lordship.
any Narayan Kumar Chaudhary like that. I have serial number 28 to
Lordship kindly comes to the
57.
second column.
Second column.
Second column.
Priority list.
Priority serial number.
Okay, priority list serial number 128.
128. 128 is the petitioner number 4 before your lordship. In terms of the 1998 notification, this list was, my lord, prepared. And accordingly, my lord, the
Nayan Kumar Chaudhary.
Narayan Kumar Chaudhary is the petitioner number 4 before your lordship.
This is Nayan Kumar Chaudhary.
Nayan Kumar Chaudhary. Nayan Kumar Chaudhary. Nayan Kumar Chaudhary is the petitioner number 4 before your lordship.
Yes.
That already, my lord, the list has been forwarded to the, my lord, concerned, my lord, West Bengal Power Corporation Limited. Now, my lord, it is for them, my lord, to give employment to one of the members of the affected families. Now, my lord, the petitioner cannot, my lord, wait indefinitely.
So only your petition number 4 name is there.
Only 4th name is with there, but subsequently, my lord, the exempted category certificate has already been issued to all the petitioners. This was in the year, my lord, 2001. This list was prepared in the year 2001, where, my lord, which was featuring only one petition.
No, list of category in respect of the category of persons or the regular interview.
Who was qualified? Who was found qualified?
Qualified in regular interview or the land losers?
Under the land losers. Under the land
losers. That is not so clear.
My lord, your lordship will see page number 70. Merit list is merit list in descending order comprising of all the above 97 suitable candidates. My lord, these are the, my lord, merit list has been prepared of all those suitable candidates, my lord, in terms of the 1998 notification, the land losers notification. And this particular list has already been forwarded, my lord, to the West Bengal Power Development Corporation Limited. This was in the year 2001. Subsequently, in the year 2015, already employment exchange certificate has already been issued to the petitioners. And the same certificate has already been, my lord, forwarded by the district magistrate to the West Bengal Power Development Corporation Limited. Now, my lord, the petitioner, my lord, cannot wait indefinitely, my lord.
No, this is 2001.
2001.
That is page 70.
Page 70. my lord.
And page 78 is 2011.
Page 78 is 2011.
After 10 years.
After 10 years, the district magistrate has forwarded the names.
So you say the Sanjay Rai and 20 others includes the present petitioners?
Include the present petitioners.
Including the petitioner number 4.
Petitioner number 1 to 4.
4 was selected in the year 2001.
But thereafter, no recruitment was given to the petitioner number 4 in terms of that, my lord, selection, my lord, list.
When you are saying that 2001, there is a selection process. So how the name of the list was sent by the DM? Why?
Subsequently, in the year 2002, my lord, the lordship will see, I just showed before your lordship that another notification was published where, my lord, the people belonging to the land losers category were placed under.
So that's why I want to know whether the 2001, that is the list, not the belong to the land losers category.
2001 list was prepared in terms of the 1998 notification.
1998 notification means?
1998 notification I placed before your lordship. Your lordship.
That is the land losers.
Land losers. Land losers.
So when 2001 there is a decision or the selection process, how the DM has sent again the names of 20 persons?
Subsequently, the DM has sent the names in terms of the 2002 notification.
So in the year 2001 selection process, there is no selection.
Selection was done, prepared, list was prepared, but recruitment was not given. Recruitment was not done. The petitioner number 4 before your lordship, my lord, was, my lord, his name is featuring in this list, but he was not given recruitment. One member of the, my lord, land losers family was supposed to be given recruitment, but even after, my lord, the petitioner's name being featured on this list, my lord, recruitment was not given. Subsequently, in the year 2002, another notification was published where, my lord, all the people belonging to the land.
What happened after the list was sent by the DM?
After the list was sent by the DM, my lord, they were under an obligation to, my lord, give recruitment to one of the members from the affected families of the petitioners. Thereafter, petitioner made several representation, my lord.
Where is your representation with the authority?
Lordship will see. Representation at page number 94. 94. Then, my lord, this was, I think, this was before the district magistrate. Then, my lord, there was several representations has been made to the chief minister also.
So what you want now? What is your prayer in the writ petition?
My prayer is, my lord.
What is the order in page 101? Order of a coordinated bench.
That was, my lord,
my learned friends clients wanted to be party to
added as a party.
To be party to be that writ application. May I make the entire thing very short, lordship? Kindly take the trouble to consider page 27.
27
of the writ application. My learned friends client has not filed the entire, has not annexed the entire notification, and that's why
This is the
some
notification,
gazette notification is there. Lordship, may I?
21st.
Yes, this is the notification. 3 notification government has issued on the basis of the power conferred under 1999 Act. Lordship, kindly consider. In exercise of the power, has your Lordship got it? In exercise of the power conferred by subsection A of section 3 of the West Bengal regulation of recruitment in the state government establishment and establishments of public undertaking, statutory bodies, government companies, and local authorities Act 1999. The governor is pleased to declare following categories of persons as exempted categories for the purpose of the aforesaid Act. 1999 Act has been enacted for giving employment of all these categories, and Lordship kindly consider item 3.
Yes.
Person belonging to the family of land loser will come within that. Now, next page, Lordship kindly take the trouble. Then I will trouble your Lordship with the flag mark. Next page, Lordship kindly take the trouble. Item 5, last portion.
Yes.
These supersedes all earlier circulars, executive orders issued from time to time by the government of West Bengal in the Labour Department relating to employment of persons belonging to exempted categories. So it supersedes all the actions. Now, Lordship, kindly take the trouble to consider the flag portion. How it is to be done. There is a procedure. District magistrate has got nothing to do with it. The flag mark portion. Lordship, kindly take the trouble.
Yes.
Persons belonging to the families of a land loser. Has the Lordship got it? For the purpose of enlistment of eligible persons of this category, the government may constitute a screening committee for the district or the subdivision. The screening committee will prepare a combined list in order of priority for the families affected by the acquisition of land and forward the same to the district magistrate concerned. Till such committee is formed, the district magistrate concerned will prepare the list of the eligible persons. So after 2002, this notification, as per the 1999 Act, it is the district magistrate to prepare the list. That office will prepare the list. Now, Lordship, kindly see subclause 6.
Yes.
The district magistrate concerned will forward the eligible persons to the Director of Employment, Government of West Bengal, and advise the enlistment of the persons to enroll their name in the exempted category cell of the Directorate of Employment, West Bengal, at 67 Benting Street, Kolkata 69, by producing supporting papers, list of eligible persons of the lands, evictee of the lands already prepared and maintained by the district magistrate in terms of the earlier circulars issued by the Labour Department shall also be forwarded to the Directorate of Employment. The district magistrate concerned advise such enlisted person to get their names enrolled in the exempted category cell of the Directorate of Employment Action. Now, nothing could be done at the level of any authority of the state. It is to be the district magistrate to forward the names to the Directorate of Employment Exchange, 69 Benting Street, and there they will be given a card. What my learned friend has just shown before your Lordship, page 73, his name has been enrolled. That is to be revalidated time to time, and it is for the Employment Exchange to send the names. And it is not that at the, let us suppose, West Bengal Power Development Corporation, Bokreshwar unit. For Bokreshwar, the land has been taken. It is not that at Bokreshwar he will get the he will get the employment. Throughout West Bengal, 99 Act, it speaks about throughout West Bengal. And any place of the government when the publication will be there for employment, then the concerned authority will send the requisition to the Directorate of Employment Exchange. They will send the name, and according to the seniority, it will be done. And this is not the single case filed by my land offense client. It is series of cases has been filed in connection with the land loser category regarding Kolaghat, Sagardighi, whatever 5 plants are there under West Bengal Power Development Corporation. Everywhere there was the direction is not to jump the queue, and it is not that the land where the person he has been evicted from the land, that place he will get it. In municipality he can get it. In government, any sector he can get it. Because the 1999 Act speaks about all the bodies. I am a government company. The land has been taken by the government and given to me, or I have taken the land, whatever is there. Now, he may get the employment in any municipality throughout West Bengal, at any place. It has broadened the entire scope of 1999 Act. And when my land offense client has not annexed the entire thing, they have only annexed the first 2 pages. So 3 circulars have been issued, how it is to be done. This is a total mechanism has been followed. The
mechanism is when a land has been used by the government undertaking or the government company, the person whose land was taken, he would be given a certificate being a land loser.
Absolutely.
Land loser. So land losers are in the portal of the concerned department.
Yes.
When there is any government recruitment, there must be some categories of persons should be there. Land losers.
EC category, yes. EC category is there, and the Directorate of Employment Exchange will
department.
Yes, yes.
From the that is the Benting Street.
Benting Street, Directorate of Employment Exchange. They will send the name.
They will send the name.
Absolutely, they will send the name, and in that process, in other cases, we have also filed the documents. We are following this whenever it is there. We are asking for it. It might so happen that for Sagurdigi, the name of the person have been given from Darjeeling. So whatever is there, it is not that for the land where the land has been taken, and
that their land was taken for the project of the
Bokreshwar Thermal Power Project.
Thermal power, say they are asking the employment in the Bokreshwar Thermal. That is not the...
No, and we cannot do it.
Okay.
Because it is 1999 Act and followed by 2002 circular, the government gazette notification. We cannot do anything, nor the district magistrate can do anything. I don't know why district magistrate that follows this given this thing. There may be other reasons that pressures were there to just offload the pressure. It has been forwarded to the Bokreshwar Thermal Power Project, and they have given a number of representation to the minister and all these things. Because this is not the process. Nobody can do anything.
No. I want to know when there is a government advertisement for recruitment.
Yes.
There are some categories: SC, ST,
EC,
PW. Okay, that is the categories. So applications are invited from the categories of people. So what would be their stand? Whether their name would be go forwarded rightly there, or they have to apply for that?
No. Now that their name has been registered,
yes,
just like employment exchange,
yes,
it has been registered. When let us suppose West Bengal Power Development Corporation has given an employment notification.
Forget about that. Forget about that. Forget about that. Everything. If there is an notification for new recruitment in the High Court,
yes,
there are a category of exempted category.
Yes.
Exempt category 2 persons.
Yes.
So whether their name would be forwarded from the department?
No.
From the
department
they have to apply for that.
No. Department will send a requisition to the employment exchange, that is 69 Benting Street, that this such and such notification has been given. 2 candidates are there for EC categories, or 2% have been reserved. Then you send the name. The employment this Benting Street will send the name. Requisition had to be has to be gone from the requisitioning body who is publishing the employment exchange.
Okay.
The notification. We cannot have anything, nor the Honorable High Court can take directly anyone on the basis of EC category. This is the act, it has to be followed. Everyone, we are also following. West Bengal Power Development Corporation, when employment notifications have been published, we send the requisition to the employment exchange. This 69 Bentinck Street, they are sending the name.
During recruitment, we are receiving several applications under exempted category. They are directly applied for that.
I don't know,
Not
Lordship.
not any requisition like
Lordship,
that.
this is not the
But
process.
it is a policy of the government on a landlord name may be forwarded to the employment exchange for registration.
Yes.
And employment exchange, it will be forwarded for recruitment according to requirement of the different authorities, my lord. Well, this is the policy. Well, according to seniority and according to their.
So registering their name in the Director of Employment, West Bengal.
Yes.
Yes.
This is the policy.
This is the policy.
Only authority concerned issued a certificate for registration of the name their employment exchange.
So in their case, certificate has already been issued. in their
73,
favor.
yes. Page 73.
So what is their stand now? What they shall do? They have to wait.
It is forwarded by the employment exchange, my lord. It is not directly appointed by the authority concerned.
My lord, kindly comes to the 2002 notification once, my lord.
No. Any
Page number
authority can,
27.
Recruitment, but according to recruitment policy, my lord, authority concerned for requisition sent to the employment exchange, and employment exchange forwarded the names according to seniority.
And Lordship, kindly one line I will show from this 27 or whatever, Lordship, the first notification, whatever I have given. The last line, first page, last line.
Yes.
These shall be applicable only in respect of cases where the land in question has been acquired by the state government on or after 17th October 1997. So after 77, everything has to be governed by this. Everything has to be governed by this.
Yes.
And we cannot do anything.
Right.
And this
We
is
have
not the
acquired the land and handed over to the authority.
My lord, this
Requiring body.
this particular notification that my learned friend is showing, my lord, this particular notification was issued by the Labour Department. Now, your lordship will kindly come to page number 28 once. Your lordship will see this supersedes all the circular and executive order issued from time to time by the government of West Bengal in Labour Department, my lord. Now, my lord, lordship kindly comes to the 1998 notification once at page number 26. This particular notification was issued by the Department of Power, not by the Labour Department. So, my lord, the subsequent notification has only, my lord, given a special, my lord, right to the petitioner to also, my lord, get recruitment under the exempted category. But the 1998 notification, my lord, cannot be nullified by the, my lord, 2002 notification. This was issued by the Department of Power, whereas the 2002 notification at page number 27 was issued by the Department of Labour.
Now, Lordship, kindly.
No, what they say, what 1998?
1998 doesn't speak about their constitutional right under exempted category. That has been given under 1999 Act by virtue of this notification. Then my Lenofest client doesn't have any right even. Land loser doesn't have any right because he has got the judgment of this Honorable Court. Division bench is there. In the case of Sabu Bakkar, where the Honorable Supreme quoting the Honorable Supreme Court judgment, this Honorable Division bench has said when the compensation has been given, the land loser doesn't have any right to for employment. That is then if my land offense speaks about 98, then my land offense client doesn't have any right. Doesn't have any right. Only it has been accrued. Only it has been accrued under 99.
98 notification already, my lord, list has been prepared in 2001.
Lordship, kindly take Lordship, kindly take the matter tomorrow. I will come up with the division bench judgment quoting the Honorable Supreme Court. The land loser doesn't have any right to the post or for any employment.
Then, my lord, what is the validity of 98 notification, my lord?
That's why.
Then, my lord, why that notification?
That's why under 1999 Act it has been given. 1999 Act has been created for giving right to the land loser under EC, exempted category.
Then, my lord, why
They-
the list was prepared in the year 2001? If, my lord, the 1908 notification has been nullified by the subsequent act.
And at least from this honorable court, single bench as well as the honorable division bench, at least I can cite before your lordship 5 to 6 judgments where it has been discarded prior to issuance of this notification, after issuance of this notification, that the queue, they cannot jump the queue. It is a government notification under the Act of 1999, so they cannot jump the queue. It has to be done in a proper way.
My lord, in terms of the 98 notification, a right was created in favor of the petitioners, my lord, that they will be receiving employment in the Bokreshwar thermal power plant. In terms of that notification, my lord, they were supposed to give recruitment to one of the members of the affected families. And petitioner, being one of the member of the affected families, was supposed to be recruited in the Bokreshwar thermal power plant. Subsequently, the 2002 notification, my lord, that has only, my lord, placed the people belonging to the land losers under the exempted category. That has not, my lord, that has only created a special right or special right in privilege in favor of the petitioner by placing, my lord, the people belonging to the land losers category as the exempted category. That was, my lord, the purport of section.
So what is your stand? Whether
You are an exempted
within the
category or 98?
98 or exempted category?
In terms of the 98 notification, they were supposed to give recruitment. That is my stand. Secondly, my lord, in terms of the 2002 notification, my lord, I was placed under the exempted category. So in terms of that, my lord, there was a special right. I was, my lord, both eligible under the 98 notification as under the 2002 notification.
98 doesn't
98
give any
notification was issued by the Department of Power, whereas 2002 notification, my lord, it was
So if
Department
you-
of Labor.
When you register under the exempted category by virtue of 2002 Act,
Yes.
you have to
98
follow
rules.
the 2002 notification.
Yes, I have
But
declared.
nowhere in the 2002.
I understand 1998, you are a special privileged person, your land has been given, but why you go to that exempted category?
In terms of the 2002 notification, my lord, my right under the 98 was not taken away. It was issued by the Department of Labor, whereas 98 notification was issued by the Department of Power. In this notification,
So you
nowhere
should not have go to the exempted category. When you go to the exempted category, you have to follow the exempted category rule.
that was a separate right, my lord. 98 right.
You cannot
and
hold
2002
two rights
are
altogether.
separate rights.
You cannot hold two rights altogether for one employment.
Even if I, my lord, consider that I am eligible under the 98 notification, but for the past 27 years have already passed. Till date, my lord, they have not given recruitment under the under the 98 notification.
Okay, what is the issue in what is the notification? What is the judgments in this matter?
Lordship, kindly take the matter tomorrow or in any day subject to Lordship can approval. I can
Tomorrow,
show everything.
tomorrow.
If my learned offense wants to rely on 98 notification, then honorable single bench judgment of this court is that my learned offense client doesn't have any right
Okay, come
because of the right because of the delay.
Come on tomorrow, first matter.
Yes, yes, first matter.
Tomorrow. First matter. First matter মানে যা আছে।
কেন ফার্স্ট ম্যাটার কি হবে? হ্যাঁ কেন পারবো না? অরুণ মান্নার ফাইলটা পাঠাবো, ওখানে সব জাজমেন্ট আছে। অরুণ মান্না আর দুলাল ভাই
Call the list.
This matter, my lord, we have completed our submission. Now, my lord, your lordship was desirous of sending notice to the government pages, my lord. My clerk, my lord, went there. My lord, he was informed, mail. Now, my lord, the email. Now, my lord, my clerk was verbally informed that Mr. Shapon Dotto has been engaged in this matter, not Mr. Somnath Ganguly.
So Mr. Somnath Ganguly is appearing for respondent number 4. I am with him, Milord, for the DPI.
Oh, he will then argue.
No, for respondent number 4 only. And the other respondents, the Commission of School Higher Education and the state, they are there, Milord, they have to argue. They have to place their case, Milord. I will place on behalf of the respondent number 4, that is the DPI.
Okay, we can start today.
Start.
Milord, today perhaps
No, Millard, possibly my learned junior friend Millard, possibly Millard has not been correctly instructed because affidavit in opposition filed on behalf of the state respondent 1 to 4 Millard conjointly.
But
So
Millard,
this fragmentation Millard at the end of the Millard argument, DPI is one part, government is the other
Yes.
part. Possibly Millard, this is a conscious misunderstanding. Right.
একসঙ্গে fail হয়েছে।
Taposh Kumar De is there.
Have you received the written notes of argument on behalf of respondent number 6? You serve a copy, sir. Have you hand over a copy? You hand over a copy at least.
On the last occasion, I said,
Perhaps what? Perhaps
I
nothing.
I shall give.
Okay, you hand over a copy. He is supporting your case.
He's a good friend of mine.
I shall provide copy.
Millard, kindly place it on record, Millard, that we sent email, Millard, we have sent. In pursuance of my lord's last direction.
So, Mr. Samanto, what can you done today?
Millard,
Your lordship, Millard, this is a serious issue, Millard, long
Yes, yes.
pending matter.
serious
And,
issue.
and Millard, the state is possibly not very serious about this issue.
But Millard, my instruction is to
State's
appear on.
conduct, Millard, for the last 2 years, Millard. I will not say it is deplorable, but Millard, they are possibly, Millard, taking side of the petitioner with their inherent generosity.
No, not perhaps not that, Millard. Millard, I have been instructed to appear on behalf of the respondent number 4 only,
But
the DPI. But well, I find, Millard, the Malafant correctly pointed out it has been opposition has been filed by 1, 2, 3, and 4 conjointly. So, but the question of perhaps this fragmentation perhaps will not be there before your lordship. But in this connection, Millard, I have to take in specific instruction, Millard, whether they would be bifurcated or the conjoint.
no, cannot be. You have used the affidavit in opposition
Yes.
jointly.
Yes.
So today, how can it be? There is affidavit in reply.
Yes,
Everything
opposition
is
by
there,
1, 2,
joint
3, and
pleadings
4
there.
jointly.
Joint pleadings are there.
Yes.
So today you cannot be bifurcated. So,
So, my lord, may I suggest one thing, my lord?
yes.
Kindly, my lord, adjourn it for this week, my lord, so that, my lord, with proper instruction, I can address your lordship whether that I have to represent the state or state will be represented by someone else, my lord. Or that much only. Because, my lord, what I have learned from their submission that some advocate was there.
If you appear, you start the matter.
Well, I have been appeared for the respondent. I have to appear for respondent 4 only.
If you appear on respondent number 4, you have to argue on behalf of him.
Yes.
Then joint pleadings are there. You have to argue on the point.
No, Lord, what happened? Will kindly visualize 1, 2, 3, 4. That is state and the DPI and the higher education. These are the parties. Lord, whether they will be addressed, they will address someone else will address your lordship. Someone else will appear or not, Lord. They have to be ascertained, Lord. Otherwise, Lord, I cannot. I have been engaged by respondent number 4. I cannot address on their behalf.
In this
In
matter,
order to eradicate, subject to correction, may I make one humble suggestion, subject to correction, Millard, that if your lordship, Millard, kindly makes a request to the government period to appear in order to eradicate this cloud or confusion, Millard, created by themselves, Millard, so that the GP can come and, Millard, remove all this confusion. Because 1 to 4 they have affirmed the affidavit. Now there is an attempt to fragment, my lord, the different compartments. DPI is one block, government is the other. So, my lord, this possibly unheard of. Even then, my lord, state represents the public interest, my lord. If your lordship, my lord, I do not wish to, my lord, because I have, my lord, completed. If your lordship kindly pass a judicial order requesting the government pleader, my lord, to come and, my lord, any day, my lord, to be mentioned.
Any day.
No, what can I do? I can provide a time to Mr. Samanto. So I can start argument on the next day.
I have to address your lordship on
Yes,
behalf of respondent
all
number
the
1.
points.
As your lordship.
Okay.
Then kindly direct pass that order, my lord.
Yes.
That can also be done.
Did I tell your lordship, my lord, subject to correction, it's a question of non-payment of a benefit showered upon us, my lord, so far it flows from the pay revision. My lord, it's a sequel to the decision taken by the pay commission.
I know.
The lordship knows. So, my lord, a decision has to be taken from the highest level of the state. Now, my lord, this kind of fragmentation at the fag end of the argument, DPI is one part, government is other part.
Yes.
GP office says, my lord, Mr. Swapan Dotto, learned senior advocate, has been engaged. Mr. Somnath Ganguly, learned senior advocate, my lord, he constantly appeared, my lord, in this matter, took time, and, my lord, so, my lord, I do not wish to, my lord, go into all these questions. These are all unnecessary.
You send the mail.
Yes, my junior sent the mail, and my clerk was also informed from the office that, my lord, Mr. Swapan Dotto, learned advocate, senior advocate, my lord, has been engaged. So, my lord, in order to eradicate all forms of confusion, my lord, if your lordship kindly makes a request and passes a judicial order, my lord, tomorrow he will come, my lord, and the other, my lord, the 1 to 3 will come and say that I will make argument on the next day. That is, my lord, that is our experience, my lord.
So it is your instruction, Mr. Swapan Dotto has
That
appeared
is
in
my,
Silver.
that is the information, not instruction given by, my lord, the office. I derived this information from the office. My clerk and I am narrating this.
Swapan Dotto in respect to 1, 2, and 3.
That has not been clarified. Only
From
state.
the initial order, 26th of April 2022, it appears, my lord, Mr. Swapan Kumar Dotto for the state.
For the state.
26 April 2022 order says this. Subsequently, in 2025, the order says Mr. Somnath Ganguly appeared for the state.
How such a matter?
Again, they will come and might say, I am not appearing in this. But again, my lord, the colossal waste of court's time for no reason.
Very well, please take down. Mr. Joyanto Samanto, learned counsel, appears on behalf of the respondent number, no, Mr. Swapan Dotto.
4.
Mr. Joyanto Samanto, learned counsel, appears before this court and submits that he was engaged to demonstrate the matter on behalf of respondent number 4.
My lord.
Mr. Kolol Basu, learned counsel, appearing on behalf of the petitioner, submits that in terms of the, in pursuance to the direction of this court, the advocate on record has issued a mail to the concerned department regarding the pendency of this matter, as none appears on behalf of respondent number 1 to 4. Today, Mr. Joyanto Samanto appears on behalf of the respondent number 4, though it appears from the pleadings that respondent number 1 to 4 has filed affidavit in opposition jointly. It has been submitted by Mr. Basu that Mr. Swapan Dotto has appeared on behalf of the state in this matter. Having heard the counsel of the parties, it appears that the argument on behalf of the petitioner as well as the respondent number 6 was concluded. None appears on behalf of the respondent number 1 to 4. Accordingly, this court has passed a specific direction upon the petitioner to serve notice upon the state authorities. Today, Mr. Samanta appears and said that he is appearing on behalf of respondent number 4 only. Considering the situation, it would be convenient for this court to fix a date for to adjourn the matter for a week, so that Mr. Samanto may demonstrate the matter before this court on behalf of the state. I make it clear that if Mr. Swapan Datta appears in this matter on behalf of 1, 2, 3, on behalf of the state, this court shall hear out the matter from Mr. Datta as well as Mr. Samanto on behalf of the state.
Great, my lord.
Let the matter appear in the list on next Wednesday at 2 p.m. That is on 23rd at 2 p.m.
Next Wednesday. Great.
I am appearing for only 6 months. Respondent number 6 unit.
এই আপনি একটুখানি মেল করে দিন না এটা
Next.
ওরা ডিপলি অবলাইজ
Should I appear for the respondent?
Yes.
Well, I'm sorry, my lord, on a lot of occasions where I could not turn up, my lord.
No, I
And
understand.
I express, my lord,
understand
my
your-
gratitude as well as, my lord, for the indulgence that your lordship has given me. I'm really grateful, my lord. My lord, the first point is, my lord, on the point of maintainability
Yes.
of the writ petition. Your lordship may kindly take me at page number 1. The writ petitioner over here is number 1 is All Bengal Fair Price Shop Dealers Welfare Association, and number 2 is General Secretary of the association.
Yes.
Then, Millard, paragraph number 1, your lordship finds, Millard, that your petitioner number 1 is a registered, recognized association of fair price shop owners of all over West Bengal and used to look after the right interest and benefits of its members, who all have been running their fair price shop businesses all over the West Bengal on the strength of their respective licenses granted by the licensing authority. Petitioner number 2 is the General Secretary of the petitioner number 1 and is a fair price shop owner.
Yes.
Now, with this, kindly take me to the prayers. Prayers, your lordship would find me from page number 19. We're asking for a declaration A that the control order of 2024 is ultra vires Article 14, 19, 1G and 21 of the Constitution, then Sashorarai, then prohibition, and Millard the other interim prayers. Therefore, Millard, the first question is, Millard, whether an association, Millard, can maintain a writ petition to challenge the validity of a control order, which is in the nature of a subordinate legislation.
Yes.
Millard, the case made out in the writ petition is that the members of the petition number 1, they would be affected by reason of this impugned control order.
Yes.
Now, my lord, but this appears to be, my lord, my lord, foundation on which, my lord, the writ petition is sought to be maintained, that the members of the petition number 1 would be affected if this control order is allowed to remain. Now, my lord, in this matter, my lord, there was an interim order which my lord was pleased to pass, but from which, my lord, an appeal was preferred.
Yes.
But if your lordship may kindly take, my lord, my affidavit in opposition, please have a look to page number 51. I'm sorry, this is 52. No, 51 হচ্ছে রসাবের order. এখানে 52 লেখা। এই যে, চলে গেছে। Now, my lord, apropos, my lord, the point that I am urging, my lord, for the present, my lord, please have a look at the division bench order, my lord, paragraph 16. It starts from page 52. Paragraph 16 is at page 57.
Paragraph 52 of the
Affidavit in opposition filed by the state.
Paragraph 52. Page 52 is the MAT 2354 of 2020.
Right.
So you are referring paragraph 16.
16. Apropos, my lord, the point I am addressing your lordship, my lord, please take paragraph 16.
Yes.
This court notices that there is a substance in the locus maintainability issue urged by the state before the learned single judge of this court. The writ petitioner number 1 is an association of FPS dealers. Unless a specific instance of infraction of accepted principles of natural justice is placed before a court, the writ court does not pass an order of stay of provision of the basis of mere apprehension, etc.
Yes.
Where the first part of this paragraph, my lord, I wish to, my lord, rely. For the time being, my lord, the honorable division bench, my lord, had found some substance, my lord, in my objection that a writ petition is not maintainable. Now, my lord, I will place before my lord, my points that the writ petition is not maintainable before this court, my lord, at the instance of an association of the writ petition, fair price shop owners. Now, please take note paragraph 3 of my affidavit in opposition. I have, my lord, canvassed this point in pleadings also.
Yes.
At the outset, it is stated that the instant writ petition is not maintainable at the instance of the writ petitioner. The writ petitioner is an association, and thus the instant writ petitioner cannot be termed as a person aggrieved due to operation of the control order. The instant writ petition is not maintainable at the behest of an association that did not itself hold any FPS license. This is very important. The association did not hold any license under the control order. Lastly, the maintainability of the writ petition is also questionable since the writ petitioner did not cite any instance where the operation of the control order adversely affected the rights of the writ petitioners, and the writ petition was filed on the basis of apprehension of an association. Then, my lord, with this, kindly have a look to, my lord, paragraph 4G at page 4. With the last line at that page, page number 4, the maintainability of the writ petition was also challenged since the writ petitioner did not cite any instance on which the operation of the control order adversely affected the writ petitioners, and the writ petition was filed only on the basis of apprehension on the aspect of interim order. Your lordship need not trouble your lordship with that for the present.
Yes.
Then we'll have subparagraph M. At page 8, the last 3 lines is stated that the grounds upon which the virus of the provisions are challenged are misconceived grounds. Then, my lord, paragraph 6, third line, it is stated that the instant writ petition is an association, and thus the writ petitioner can be termed as a person aggrieved due to operation of the control order. Then paragraphs 28 and 29. But kindly note down the paragraph numbers. These are the places where we have raised the point of maintainability of the writ petition.
Yes.
Now, my lord, this has been dealt with by the petitioner in their affidavit in reply, paragraphs 6, 7, and 12.
Paragraph 6, 7, and 12.
Yes. At paragraph 6, I say that being the registered association of the fair price shop owners and looking after the right interest and benefits of the members, as such can file a writ petition on behalf of its members. Then we'll at paragraph 7, please take the last, the subparagraph. I further say that since the state control order has not been framed in consonance with the central control order, and since the same is promulgated contrary to the constitutional rights and guarantee provided to the members, it cannot be said that the writ petition has been filed on apprehension. And lastly, we are at paragraph 12, the third subparagraph. I say that since the petition number 1 is a registered association looking after day-to-day right, interest and benefits of its members who are running the fair price shop all over West Bengal, the writ petition for the interest of its members is very much maintainable.
Yes.
Therefore, my lord, the sum and substance is that promulgation of this control order affects or may affect the rights of my members. Therefore, the writ petition is maintainable at the instance of an association. This is the sum and substance, my lord, of the defense. Now, my lord, my first respectful submission is, my lord, as your lordships have all along held, that the writ court is a court where, my lord, an established legal right, if infringed or if sought to be infringed, my lord, a writ court can be approached for redressal of the affectation of the rights which has already stood affected or may get affected in future. Therefore, the precondition is that there must be a subsisting legal right or an existing legal right and infraction thereof. And this applies to the petitioner. So the petitioner must come and say, X is my legal right, Y is trying to infringe my legal right, or Z has infringed my legal right. This is not the case. Here, X is coming saying that Y's legal right or Z's legal rights with whom I am associated may be affected. Let us, my lord, test this proposition whether an association can file a writ petition on behalf of its members, alleging or apprehending that their rights may be affected because of passing of a subordinate legislation. I will not burden your lordship with many judgments. Your lordship may kindly take, my lord, there is a judgment of our High Court in 1977. But this is reported in this a division bench judgment of Justice Murari Dotto, 1977, Calcutta High Court Notes 965. But this is a tenants association who's coming.
Yes.
CHN 1970 SCC online দেবো 1977 কবে থাকলে দিয়ে দেন 1977 SCC online care 221 But here kindly take me at paragraph number 2. This is also a 226 petition.
Yes.
The appellant who is described as so and so association challenged a declaration under section 6 of the Land Acquisition Act which was preceded by a notification of Section 4 of the Act. The notification under Section 4 was published. It was inter alia stated therein that the lands comprising premises number, etc., were likely to be needed for public purpose for construction of so and so of KMDA. After hearing the objections filed by the interested persons, including the tenants of premises under Section 5A, the declaration under Section 6 was published. In the declaration, it was also stated that the acquisition would be made at the expense of CMDA. It was contended by the appellant in the writ petition that CMDA was neither a local authority, etc. Your Lordship may skip over that. But after 6 lines, at the hearing of the rule nisi, my Lord has found that.
Yes.
2 preliminary objections were raised on behalf of the respondents, namely that the appellant had no locus standi to maintain a writ petition challenging the declaration under Section 6, and that a majority of the members of the appellant having filed claims under Section 6, filed claims under Section 9 of the Act, they have waived their right to call in question the legality of the acquisition. The learned judge upheld the preliminary objections of the respondent and have held that the appellant had no locus to maintain a writ petition and that most of its members filed claims for compensation. They have forfeited their right to challenge. He also held that CMDA, a local authority within the meaning of so and so, etc. Upon the findings, he discharged the rule and hence the appeal. We may first of all consider the locus standi of the appellant to maintain a writ petition. After the notification under Section 4 was published, the tenants of the premises formed themselves into an association, which is the appellant before us. The appellant has been registered under the Societies Registration Act. Article 226 provides for remedy for infringement of a fundamental right or legal right of a person. The condition precedent to the granting of relief under Article 226 is the existence of a fundamental or a legal right of a person and the infringement of such right. The right which is the foundation of an application under Article 226 is a personal and individual right. This is very important. The legal right may be a statutory right or a right recognized by the law. The principles of law in this regard has been recently restated by the Supreme Court in so and so. In that case, the Supreme Court has observed that it is elementary that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as a legally protected right before one suffering a legal grievance can ask for mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. In the instant case, the persons who will be affected by the acquisition of the lands comprised in the premises are the tenants occupying the same, besides the owner thereof, but surely not the appellant. The appellant has no legal right and therefore there is no question of infringement of a legal right. The appellant has no interest in the land and the premises sought to be acquired. He is not therefore a person aggrieved. The learned judge has rightly held that the appellant has no locus standi. But I don't trouble your lordship with the rest part of paragraph 4. But sum and substance is that there has to be a personal right, affectation of that personal right, and that person can come before the court. In this case also, my lord, it was said that the tenants would be affected. Tenants are my members. Therefore, the association had the locus. Yes. But I'll come back to paragraph 5 after some time. But for the present period, only paragraph 4 of this writ petition, of this judgment. Then paragraph 6. That's waiver, I'll not trouble your lordship. So, but this is one of the judgments of this court, Miller, which says that this is a personal right. A person may be affected. Whoever is affected will come and enforce his right before the writ court. And somebody else saying that I am interested about his right, Milord cannot come up before this court. But the second judgment is this is also of our court, 1993, volume 2, Calcutta Law Journal, page 99. But this is also a division bench judgment. This is, of course, at the leave to appeal stage. Whether, my lord, an association allegedly affected by an order of a single judge, whether, my lord, can pray for leave to appeal. My lord, please take paragraph 6. Well, here, my lord, it was sought to be contended that the association is a rival in trade. Please take paragraph 6. No case has also been made as to how the individual members of the association who are the operators are being affected by the order of the learned single judge. The learned single judge has directed that in view of the judgment of the Supreme Court, the operators who were granted successive temporary permits, the permits had to be made permanent. The association is representing the operators who are plying vehicles, and unless a case is made out that even when individual operators are seriously affected by any judgment, no leave can be granted in this connection on the basis of locus standi of the operators to maintain a writ petition. Reference was made to the decision of Kerala High Court in etc. We will kindly skip over the rest part. Please take note paragraph number 7. In our view, the association of minibus owners cannot be granted to have cannot be granted, it should be leave, not have, leave to prefer an appeal when the association itself is not affected by the order passed by the learned single judge, trial judge. And unless it can be established that the association is prejudicially affected by the order passed by the learned trial judge, the right of the association it should be no right, has been infringed. The association cannot have any right to complain, and we do not find any reason whatsoever why the association can feel itself aggrieved by the order passed by the learned trial judge. If the association has not been conferred any right under the statute, and if the association is not affected by the order, the association cannot come forward before this court alleging that the association is aggrieved. It is one thing to say that the individual operator is aggrieved, and it is quite different thing to say that the association is aggrieved, and the association cannot be said to be aggrieved if some of the members of the association are aggrieved, inasmuch as the association is a separate and legal entity, and the right of an individual member cannot be equated with the right of the association. Accordingly, we do not so and so. Therefore, an association's right, if aggrieved, if established, can maintain. It is not the case of the petitioners over here that the association's right is getting affected. The right that is getting affected or may get affected is that of the members.
Yes.
Therefore, we are going by this judgment of our High Court, division bench of our High Court, unless the association can show that the association is getting aggrieved, no writ petition is maintainable because its members are getting aggrieved. But this is the second judgment, where there is a later judgment of the Madras High Court, a single judge of the Madras High Court in 2011. But if your Lordship may kindly have a look to this, this is reported in 2011, volume 4, CTC 369. This is concerning some cable operators.
Yes.
Kindly take me to paragraph 16 of this judgment.
Yes.
The petitioner association who filed this writ petition cannot have any personal grievance in the matter, and at best only its members can have any grievance, but this is the case made out by them. Also, the petitioner has not filed the writ petition in public interest and disclosed the circumstances which prevented the affected persons from approaching the court. Assuming that the members of the petitioner association are affected by an act of the respondent numbers 2 and 3 for the purpose of enforcing the rights of the members, writ petition at the instance of the association is not maintainable. Even countenancing that the writ petition filed by the association is maintainable as contended by the learned counsel for the petitioner, the necessary ingredients that the members of the association are unable to approach the court by reason of poverty, disability, or socially or economically disadvantaged position has not been established by the petitioner. It is also not the case of the petitioner that he has filed this writ petition in public interest. But all facets are applicable in our case. In the instant case, a perusal of the entire materials would reveal that no member of the petitioner association has made any complaint except a representation by the petitioner association for a general grievance, and it is always a person aggrieved and affected by the act committed by the cable service operator that has to make a complaint, and only thereafter the same shall be dealt with. In the absence of any such complaint, it is revealed that no case is made out by the petitioner association for entertaining the writ petition, therefore not maintainable. Yes. Therefore, my lord, the sum and substance of all these judgments are merely because the members can be affected, where the writ petition is not maintainable at the instance of the
Association.
Why? Because neither any legal right has been shown to your lordship of the association, nor any legal injury of the association has been shown to your lordship. And my lord, I am conscious that there is a second writ petitioner. But the second writ petitioner, my lord, also does not say that he is doing moving this writ petition on his personal capacity. He says it is stated in paragraph number 1 that the petitioner number 2 is the general secretary of the petitioner number 1 and is also a fair price licensee or owner, whatever. It is not the general manager is not moving the court in person
as
a person.
FPS license dealer.
Yes. Saying that Sri so and so, general manager of so and also a licensee. Therefore, his capacity over here is not as a licensee,
but as an association, a member of an
association or a portfolio holder of the association. Maybe he has been authorized to move this petition, but finally he is doing so for the association. Therefore, my lord, the second writ petitioner's right or infraction or injury to any legal right is also not being established or even, my lord, pleaded in the writ petition. Therefore, my lord, in my very respectful submission, this writ petition, my lord, should be dismissed, my lord, on the point of locus standi. Now, my lord, without prejudice, if your lordship, my lord, invites me to proceed further on the merits, I am ready to, my lord, address your lordship. Unless your lordship feels that your lordship would decide the maintainability and then proceed with the matter. Otherwise, also, my lord, I am ready.
So, today you have already filed the affidavit in opposition,
Yes.
everything. So you deal with, we shall deal with
Very-
all matters.
Very, very good.
It will be better.
Very good. Now, my lord, here, my lord, the grievance of the writ petitioner is primarily that, my lord, there is a central control order which is called the Targeted Public Distribution Control Order 2015.
Yes.
And there is the impugned West Bengal Public Distribution System Control Order 2024. Where the primary grievance is that the state control order is not in tandem with the central control order. This is one. And the other point is that after the National Food Security Act has come into operation, Milord, there is no question of formulating these kinds of control order. Well, these are, Milord, two fundamental points, Milord, on which, Milord, the writ petition is founded.
Yes.
Now, so far as the second point is concerned, Milord, I would like to address your Lordship on the second point first, that what is the scope of the Essential Commodities Act from which where all these control orders flow, and what is the scope of the National Food Security Act.
Yes.
Now, my lord, from the competence of the legislation is concerned, where my first respectful submission is, my lord, both the Essential Commodities Act as well as the National Food Security Act, my lord, both are framed under, my lord, entry 33 of list 3 or the concurrent list in the Constitution.
Yes.
Constitution আছে তো কাছে? বের কর।
Yes.
Now, my lord, so far as, my lord, the Essential Commodities Act is concerned, Food Security Act, my lord, draws inspiration, my lord, from Article 47 of the Constitution. But if your lordship is having, my lord, a constitution, my lord, kindly
Yes.
have.
Yes.
First, kindly take, my lord, entry 33 of this of the concurrent list.
And the 33.
Yes. It says, my lord, trade and commerce in and production, supply and distribution of. May the lordship may skip over A, please take B. Foodstuff, including edible oil seeds and oil. Therefore, my lord, entry 33 is the topic of legislation on which, my lord, both the EC Act as well as, my lord, the Food Security Act, my lord, has been enacted. Now, kindly take, my lord, Article 245.
Yes.
That's found by Article 245. Subject to the provisions of this Constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or part of the state. No law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. Therefore, the Parliament can make law for the entire country or for part of the country. Then kindly take 246. Notwithstanding anything in clause 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in list 1 of the 7th schedule in this Constitution. 2. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of a state shall also have the power to make laws with respect to any of the matters enumerated list 3 in the 7th schedule of the Constitution referred to as the concurrent list. Therefore, Miller, under 246(2), Both parliament and the state legislatures, they can frame laws. That is why in EC Act, your lordship finds the state amendments are there, or the control orders are framed under 3 and 5. Now with this, kindly take me the directive principle. Please come to Article 39. Yes. Certain principles of policy to be followed by the state. The state shall in particular direct its policy towards securing, then B, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. So, my inspiration of to formulate and promulgate EC Act is under 39(2), that the material resources should be distributed for the best to subserve the common good. Yes. Then, Millard, kindly take Article 47. This is under which the Food Safety Act has formulated or enacted. Duty of the state to raise the level of nutrition and standard of living and to improve public health. Yes. The state shall regard the raising and level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. Yes. Therefore, the state's obligation to raise the level of nutrition and standard of living is provided, in Article 47 of the Directive Principles. Now, kindly have a look to the purpose for which the Food Safety Act has been enacted. Well, my learned friend, I believe, has annexed those. Kindly take me to page number 24. Yes. Of the writ petition. But the Food Safety Act has been annexed to the writ petition. Yes. It says an act, the preamble, an act to provide for food and nutritional security in human life cycle approach by ensuring access to adequate quantity of quality food at affordable prices to people who live a life with dignity and for matters connected therewith or incidental thereto. So these are, the words, which your lordship will find, from Article 47 of the Constitution. So therefore, the purpose of the Food Security Act is to provide quality food and to ensure, that nutritional security and standards are maintained and adequate quantum of food is provided to the citizens. Now, kindly take the Essential Commodities Act. But Essential Commodities is annex for me, ne? But if your lordship is having it, kindly see the preamble. I will not trouble you with the objects and reasons. Essential Commodities Act says an act to provide in the interest of general public for the control of production, supply, distribution of and trade and commerce in certain commodities. Therefore, the purpose of these two statutes, although the legislative head is the same, that is entry 33 of list 3, but the purpose is completely different. One ensures quality, the other is concerned with the production, distribution,
Yes.
and management of foods.
Control the production, supply, and distribution.
Therefore, the purpose of these two statutes are different. Therefore, a question will arise that whether the PDS control order 2020 targeted PDS control order of 2024 can be considered to be contrary to the Food Safety Act. Because this targeted control order, they all flow from section 3, 5, and there is a notification called GSR 800.
Yes.
These all flow from Essential Commodities Act and other things. Whereas the Food Security Act, the purpose being different, please consider whether the targeted PDS control order of 2024 by the West Bengal, these are executive orders, I won't say it's
yes,
of the legislature, whether these can be construed to be in contravention of the National Food Security Act. Now, apropos this, because extensive submissions have been made before my lord, apropos this, please take 5 or 6 sections of the National Food Security Act. It starts at page 24 where I placed. Now, please take, for example, section 3 first.
Provisions for food security.
Provisions for food security, very particular security. Subsection 1 says every person belonging to so and so identified under section 10 shall be entitled to receive 5 kilograms of food grains per person per month at subsidized price specified so and so under the targeted public distribution system. Then kindly skip over the provisos. Then 2. The entitlement of the persons belonging to the eligible household referred to in subsection 1 at subsidized prices shall extend to 75% of the rural population and up to 50% of the urban population. Where it is securing quality food for the population, 75% is the target in the rural areas and 50% is the target in the urban area.
Yes.
And how will it be done? Under the targeted public distribution system. Now the question would arise is whether targeted public distribution system is a product of this statute or not. It is not a product of this statute, it is a product of some other statute, because Essential Commodities Act was in the field, operating, even operating today.
Regarding distribution, control, and supply.
Yes.
And this act, that is the NFSA, is the security of the food to the public.
Right, with nutritional standards, etc. Then kindly take me at section 9. Where some of the features made, I'll only demonstrate. For example, section 9.
Yes.
The percentage coverage under the targeted public distribution system in rural and urban areas for each state shall, subject to subsection 2 of section 3, be determined by the central government, and the total number of persons to be covered in the rural and the urban areas of the state shall be calculated on the basis of the population estimates as per the census, of which the relevant figures have been published. So the central government will fix the percentage, and the percentage would be applied based on the census. If it is 35%, then what would be the number of the persons that is to be decided based on the census?
Yes.
Then please take 10. Identifying the households. The
Yes.
state government shall, within the number of persons determined under section 9 for the rural and urban area, identify the households to be covered by the so and so to the extent under 3.1 in accordance with guidelines. The remaining households as priority households to be covered under the targeted public distribution system in accordance with the guidelines that the state government may specify, provided, etc. Then subsection 2, the state government shall update the list of eligible households within the number of persons determined under section 9 for the rural and urban areas in accordance with the guidelines framed under subsection 1. The reforms, etc., has been provided. Now kindly take section 22.
Yes.
Here, the central government allocates the quantity. The central government shall, ensuring the regular supply of food grains to the persons belonging to eligible household, allocate from the central pool the required quantity of food grains to the state government under the targeted public distribution system as per entitlement under section 3 at the price specified in schedule 1. The central government shall allocate food grains, etc., etc., etc. Then section 23 provides for funds. In case of short supply of food grain from the central pool to a state, the central government shall provide fund to the extent of short supply to the state government.
Yes.
Then 24 is state is to implement the central scheme. The state government shall be responsible for the implementation and monitoring of the schemes of various ministries and departments of the central government in accordance with the guidelines issued by the central government for each of the scheme and their own schemes for ensuring food security to the targeted beneficiaries in the state. Under the targeted public distribution system, it shall be the duty of the state government to do so and so, so and so. But nothing to do with production, distribution, etc. Now kindly take in the backdrop of this being the object of the legislation, please take paragraph 12.
Paragraph?
I'm sorry, section 12. At page 28.
Yes.
The central and the state government shall endeavor to progressively undertake necessary reforms in the targeted public distribution system in consonance with the role envisaged for them under this Act. The reform shall inter alia include doorstep delivery of food grains to the outlets, application of information and communication technology tools including end-to-end computerization in order to ensure transparent recording of transactions at all levels and to prevent diversion, leveraging Aadhaar for unique identification with biometric information of the entitled beneficiaries for proper targeting of benefits under this Act, full transparency of records, preference to public institutions or public bodies such as panchayats, self-help groups, cooperative societies in licensing of fair price shops and management of their shops by women and their collectives, diversification of commodities distributed under the PDS over a period of time, support to local public distribution models and grains banks, introducing schemes such as cash transfer, etc. So therefore, for the targeted public distribution system, this statute only says that you upgrade the targeted public distribution system, nothing more. But my purpose is to demonstrate before your lordship that the targeted public distribution system control order is not a product of
NFSA. Purpose of both the acts are
that
different.
different. ওকে আজকেই দেবে বলছে ও বলো না সোমবার নিতে কি আছে তারা এই মামলায়
সাবমিশন ফিক্স করো যে কি সামসের গঞ্জে যাব অ্যাপ্লিকেশন হচ্ছে এরকম কমেন্টস বাটে কেন
Yes. Which other matter? Okay. I will we are concluding this. Only 15:7 is there. Today is not 3:30 like that.
No, no 3:30.
Today we have time.
Today is not a day to waste at 3:30.
Yes.
Now, my lord, kindly have a look to the essential control order at page 42 of the writ petition. DSR 213, whereas the central government is of the opinion that it is necessary and expedient so to do for maintaining supplies and securing availability and distribution of essential commodities, namely food grains under the targeted public distribution system.
Yes.
Therefore, supply, availability and distribution. Now, therefore, in exercise of powers conferred, Food Security Act is of 2013.
Yes.
This is coming on 20th of March 2015. Food Security Act কবে চাই? Try to check it out. So, Food Safety Act, National Food Security Act, was in operation. Now, therefore, in exercise of powers conferred by Section 3 of the Essential Commodities Act and in supersession of the PDS Control Order 2001, except as regards things done or omitted to be done before such supersession ends, save as otherwise provided hereunder, the central government hereby makes the following order. Namely,
Yes.
that is the order. Now, various provisions have been made. Fair price shop has been defined. Here, kindly take paragraph 3 at page 46. Identification of eligible household.
Yes.
The state-wise percentage coverage of eligible households under the Food Security Act in rural and urban areas respectively for receiving subsidized food grains under the targeted public distribution system shall be as in column 4 of annexure 1. So, identification in under the Food Security Act.
Yes.
Here, distribution. Then 2 says the state-wise ceiling on coverage of number of persons belonging to eligible household for receiving subsidized food grain under the targeted public distribution system indicated in column 5 of annexure 1 shall be in the following 2 categories. Then where categories are mentioned, This is how they operate. Kindly take a look at sub paragraph 12 under paragraph 3 at page 49.
Yes.
The final list of eligible households shall be displayed in the public domain, including office of the local authorities on the state web portal, showing the category-wise names of eligible households and their members. So this is only a mechanism at how this would work. Kindly take now paragraph 4 at page 50. Ration cards, Millard, will be issued. The state government shall issue ration cards to the eligible households as mentioned in the final list specified in subclause 12 of clause 3. So first identification by this central
NFSA.
Under NFSA, then it comes to the schedule, then Millard ration cards are issued Millard under section under paragraph 4. Then Millard skipping over a few paragraphs where these are made all mechanisms Millard which have been stated. Then your lordship may kindly take licensing, para 9 at page 60.
Yes.
The state government shall issue an order under section 3 of the Act, but not inconsistent with this order for regulating the sale and distribution of essential commodities. But this is very, very important for me. What is the binding that the state government is given under this central control order is the regulation of sale and distribution should not be inconsistent with the order. Only regulating the sale and distribution. But I repeat, regulating the sale and distribution.
Or regulating the sale and distribution of essential commodity.
And for that purpose, Millard, subparagraph or clauses 2 onwards. Then Millard, kindly take me paragraph number 10. How the fair price owner will disburse food grain to the ration card holder as per entitlement under the targeted public distribution system. Maintenance of records, etc. Then 12 is transparency, 13 is penalty. Kindly take me section clause 13.
Yes.
If any person contravenes any of the provisions of this order, he shall be liable to punishment under section 7 of the Act. 7 of Essential Commodities Act, not Food Security Act. Then there is a provision of appeal under clause 15, etc. Where the point has been urged before my lord that the West Bengal control order is not in tandem with the central control order. But my very respectful response is, my lord, only paragraph number 9 of this control order, central control order, says that I can issue order or the state can issue order not inconsistent with the central control order only to the extent of regulating the sale and distribution. Sale and distribution.
Yes.
Therefore, my lord, the submission that has been made that the entire control order of 2024 by the state is contrary to both the National Food Security Act as well as the Central Control Order, my lord, in my very respectful submission, my lord, is not correct, my lord, in view of, my lord, the provisions and the object of the legislation. Now, my lord, I'll take your lordship, my lord, through the Essential Commodities Act. But kindly take, my lord, section 3 of the Essential Commodities Act.
Yes.
Section 3 says, if the central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing supplies of essential commodities or for securing their equitable distribution and availability at fair prices, or for securing any essential commodity for the defense of India or the efficient control of military operations, it may by order provide for regulating or prohibiting the production, supply, and distribution thereof and the trade and commerce therein, without prejudice to the generality of the provisions of the powers conferred by subsection 1. An order made thereunder may provide for regulating by licenses, permits, or otherwise the production or manufacture of any essential commodity, for bringing under cultivation any waste or arable land, etc. Then C, for controlling the price at which the essential commodities may be brought and sold. D, for regulating by licenses, permits, or otherwise the storage, transport, distribution, disposal, acquisition, use, or consumption of essential commodity. For prohibiting the withholding for sale of any essential commodity ordinarily kept for sale. For requiring any person holding in stock or engaged in production or in business of buying or selling of any essential commodity to sell the whole or a specified part of the quantity held in stock or produced or received by him, or in the case of any such commodity which is likely to be produced or received by him, to sell the whole or a specified part of such commodity when produced or received by him to the central government or a state government, or to an officer or agent of the state government, or to a corporation owned or controlled by such government, or to such other persons or class of person, and in such circumstances as may be specified in the order.
Yes.
So, this is the power of the central government to frame control orders on so and so topics, which does not include any food security, safety, nutrition, etc.
Yes.
Then there are two explanations. Explanation 1, an order under this clause in relation to food grains so and so may having regard to the estimated product in the concerned area, etc. Then explanation 2, what is the meaning of production? But I don't trouble you with that. Then please take subsection 3.
Yes.
Where any person sells any commodity essential commodity in compliance with an order made with reference to clause F of subsection 2, there shall be paid to him the price. But these are made all emergency provisions. 3A, these are all emergency provisions. 3B, 3C. Your Lordship need not be troubled with those. Now kindly take, my Lord, section 5. Section 5 says delegation of power. Section 3 is the power of the central government. Section 5 says the central government may by notified order direct that the power to make orders or issue notification under section 3 shall in relation to such matters and subject to such conditions, if any, as may be specified in the direction be exercisable also by such officer or authority subordinate to the central government or such state government or such officer or authority subordinate to a state government as may be specified in the direction.
Yes.
Therefore, to frame the control orders under section 3, where powers can also be delegated to any officer of the central government or to the state government or to an officer of the state government.
Yes.
Now, my lord, where the word over here is by notified order. Section 5 says by notified order, central government may delegate. Now, the notified order, আছে তো কাছে এখানে 800টা দেখো কোথাও আছে কিনা GSR 800 ওর পরপরই থাকবে হয়তো। Please give me a moment where there's a important GSR ওখানে থাকবে এখানে তো এগুলো তো সব কন্ট্রোল অর্ডার যশোরকে দিয়ে দিবি ঠিক আছে তো আছে আমার কাছেও আছে আছে আমার কাছেও আছে 681 আছে 682 আছে 680টাই নেই না এটা 800 সরি But there is a notification which is GSR 800, but it's quoted in various judgments. 85 to SCC আছে or 85 to SCC তে নয় 99 to CHM তে যে কোনো একটা Visual International এটা একটু দিয়ে জজ সাহেবকে দিয়ে দেবো। But if your lordship may kindly have a look to me at a soft copy of it, my lord, I will provide a printed copy of this. But this is a notification number GSR 800, which is dated 9th of June 1978, which was issued, my lord, by the Ministry of Agriculture and Irrigation, Department of Food of the Government of India.
Yes.
But it says in exercise of powers conferred by Section 5 of the Essential Commodity and in supersession of the order of the Government of India in the Ministry of Agriculture, dated 20th of June 1972, the central government hereby directs that the powers conferred on it by subsection 1 of section 3 of the said Act to make orders to provide for matters specified in clauses A, B, C, D, E, F, H, I, I, and J of subsection 2 thereof shall in relation to foodstuff be exercisable also by a state government, subject to the conditions that such powers shall be exercised by a state government subject to such directions, if any, as may be issued by the central government in this behalf, that before making an order in relation to any matter specified in clauses A, C, and F, or in regard to distribution or disposal of foodstuff to places outside the state, or in regard to regulations or transport of any foodstuff, under the said clause D, the state government shall also obtain prior concurrence of the central government, and that in making an order relating to any of the matters specified in clause I, the state government shall authorize only an officer of government. Therefore, this is the notification at it says where section 5 notified. Now, this is the notification, and subject to such conditions and restrictions which your lordship has found in Millard section 5 are Millard 1, 2, and 3 over here.
Yes.
So this is where, Millard, the central government draws power from, to frame the control orders, where the targeted control order of 2024 is an exercise of executive powers, Millard, framed under section 3, read with section 5, read with GSR 800.
Yes.
Now kindly have a look to, Millard, certain provisions of the 2024 control order, which is challenged, Millard, in this proceeding. Please take, Millard, page 75 of the writ petition.
Is an exercise of section 3.5 and GSR 800.
It's flowing from it.
Yes.
Where page 75, where kindly take the preamble. Whereas the Government of India, Ministry of Consumer Affairs, so and so, in exercise of powers conferred by section 3 of the EC Act, has issued the targeted public distribution control order 2015 by GSR 213, which I have already placed. And whereas in pursuance to clauses 4, 9, 10, 11, 12, 13, 14, and 15 of the targeted so and so 2015, the state government is empowered to issue order under section 3 of the Essential Commodities Act for regulating ration cards, licensing, and regulation of fair price shops, operation of fair price shops, monitoring, ensuring transparency and accountability, penalty, powers of inspection, search, seizure, and appeal, and for matters connected therewith and incidental thereto. Now, therefore, the governor, in exercise of powers conferred by section 3 and 5 of the Essential Commodities Act, read with the government of ministry, etc., Department of so-and-so, GSR 213E, dated 20th of March 2015, pleased to hereby make the following order. Therefore, my lord, the power flows from 3 and 5. But I really do not know why GSR 213 has been used over here. Possibly, my lord, this is of this should not be of any relevance because the power is not derived from 213. Power is derived from section 3 and 5.
GSR 213 is the
Is a central
PDS 15.
2015.
Central
Yes,
control order.
yes,
Sorry,
yes, yes. But the power actually flows from 3 and 5. That is mentioned.
IC Act.
Yes. Then, my lord, various provisions, for example, my lord, clause 2J, fair price shop, 2K is the family members defined, 2M is Food Security Act, 210 is the relative definition.
Yes.
Then kindly see, my lord, section clause 3, eligibility for new ration card. Clause 4, issuance of ration card. 5 is activation, deactivation of ration card. Then 6 is application, modification, updation of ration card. 7 is the power of government to make alteration or amendments. Then 8 is creation of vacancy and licensing of fair price shop. 9 is procedure for creation of fair price shop and appointment of licensee. 10 is power of the state government to grant license to a government-owned company. 11, eligibility criteria for application. 12 is disqualification. 13 is selection procedure. 14 is issue of license. 15 operation. 16 duties and responsibilities of dealer. Then comes 17, manner of distribution of public distributions commodities to the ration card holders. 18 is working hours and leave of fair price. Then 19 is provision for leave of dealer. 20 provision for resignation. 21 it goes on bar to shift, etc., etc. So and so. Then 27 is creation of distributorship and appointment of licensee, etc. It goes on and on and on. Then offenses penalty, my lord, we have at page 102, clause 44, 45, 46, 47, 48, 49, etc. Then mode of payment comes, etc., etc. Then we have the appellate body, so and so. Where my purpose is to demonstrate that, my lord, in view of, my lord, clause number 9 of, my lord, the targeted control order or central control order of 2015, where the only precondition is where it should not contravene. I mean, the state control order should not contravene
Sale and distribution,
yes.
regulation of sale and distribution.
regulating the sale and distribution of essential products. But my learned friends have not made out any case that the 2024 control order infringes clause 9 of the central one. But the argument made is relative. It does not include XYZ. The argument made is in case of compassionate appointment, someone will get excluded.
Penal action.
The argument is penal action without show cause notice, without making known the charges, somebody would be punished XYZ. But my very respectful submission is, my lord, unless a case is made out for infraction of clause number 9, if at all,
Central control order.
of the central control order, my lord, nothing can be looked into even. But that case has not been made out. Where a case is sought to be made out with respect, my lord, going beyond clause number 9 of the central control order, that the entire 2024 control order is not in tandem with 2015 control order. But that possibly, my lord, that case cannot be made out. But assuming for argument's sake, that the entire 2024 state control order is divorced the 2015 Central Control Order. Assuming for argument's sake it is DHOS. But my lord, the court's attention can be drawn only in respect of clause number 9.
Yes.
Which in my very respectful submission, my lord, no case has been made out.
Yes.
Now, my lord, assuming for argument's sake, my lord, that there is an infraction of clause number 9. Assuming for argument's sake, my lord, there is a violation of clause number 9. But please look into, my lord, this cellular operator's judgment, which is reported in 2016-7. তোরা রিলাই করেছিলি না সেলুলার অপারেটর? But this is reported in 2016 volume 7 Supreme Court cases 703. আমার তো মনে হচ্ছে তোরাই দেখেছিস, হ্যাঁ? I think when my learned friend Mr. Shahara had cited this.
Yes.
Please check me paragraph number 34. But this is the parameter, my lord, on which these are all, my lord, without demur. I say, my lord, it is not contrary to the central control order.
Not inconsistent with the central.
Yes. Assuming there is some inconsistency. But kindly see, my lord, in this judgment, my lord, the parameters have been noted. Kindly have a look to para 34. Yeah.
Para 34.
But I stand corrected by my learned friend. This was not cited by them. I think I had cited this, my lord, in the first round, this judgment.
Cellular operators.
Yes. But please take para 34. In state of Tamil Nadu, this court, after adverting to the relevant case laws on the subject, laid down the parameters of judicial review of a subordinate legislation generally thus. Para 15 is quoted, there is a presumption in favor of constitutionality or validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds. What are the grounds? A, lack of legislative competence to make the subordinate legislation where no case made out.
Yes.
Number B, violation of fundamental rights guaranteed under the Constitution, where an association cannot have a guaranteed constitution fundamental right in this regard at least. C, violation of any of the provisions of the Constitution not shown. failure to conform to the statute under which it is made or exceeding the limits of the authority conferred by the enabling act. Nothing of that sort. They have not shown any failure to conform to the
Exceeding the limits of authority like that
from the EC Act.
from the EC Act.
Then repugnancy to the laws of the land, that is any enactment, doesn't arise. F, manifest arbitrariness, unreasonableness to an extent where the court might say that the legislature never intended to give authority to make such rules. Or merely it should be so arbitrary that your lordship has to come to a conclusion that the legislature or the the legislature never intended the government to make this kind of a rule. Or in other words, the legislature or the executive body could not have arrogated unto itself the jurisdiction to frame this rule at all.
Yes.
Then quoted para 16. The court, considering the validity of a subordinate legislation, will have to consider the nature, object, and scheme of the enabling act, and also the area over which power has been delegated under the act, and then decide whether the subordinate legislation conforms to the parent statute. But no argument made on this. Where a rule is directly inconsistent with a mandatory provision of a statute, then of course the task of the court is simple and easy. But where the contention is that the inconsistency or non-conformity of the rule is not with reference to any specific provision of an enabling act, but with the object and scheme of the parent act, the court should proceed with caution before declaring invalidity.
Yes.
My respectful submission is that your lordship has not been invited by my learned friends to go into this fact at all, that it is contrary to the parent act. It is contrary to the enabling act. It is contrary to the object and scheme of the parent act, EC Act. My lord has not been, invited to make any determination on this aspect. No argument has been made. The argument is that it is contrary to the Food Safety Act.
Contrary to the Central Act.
And contrary to the Central Control Order.
Control
Order.
Control Order.
And I have shown, my lord, that the Central Control Order only make that limited restriction. That case has also not been. Clause 9. And the Central Control Order is not my enabling act.
Yes.
I do not know why GSI 213 has been mentioned over there. My enabling act is the Essential Commodities Act. And if at all through any notification, it is GSR 800. That's why I troubled your lordship to have a look to GSR 800. Therefore, my lord, none of the grounds, none of the exceptions that your lordships have called out to entertain a challenge to a subordinate legislation.
Yes.
As is attracted in this case or even argued in this case.
Yes.
But the last judgment on the point, I was not that enthusiastic to place this judgment, but I have to place this judgment. I've placed it not at the first hearing also. But today, Milord, a lot of arguments have been made in regard to the specific provisions, that how one provision affects somebody's right, another provision may affect somebody's right. Someone has been imposed with a penalty, somebody has not been conferred with any right of hearing, XYZ. Milord, a lot of submissions have been made, Milord, which I have already dealt with my affidavit in opposition in extenso, Milord. If required, Milord, I can place those. But what is very important is today, apropos the writ petitioners, but I'm not talking about I'm not referring to their members. Apropos the writ petitioner, Milord, please consider, Milord, where today the writ petitioner is at a position where, Milord, only, Milord, a subordinate legislation has been enacted. This subordinate legislation has not affected its right. Assuming it is capable of affecting its right. Yes, assuming it is capable of, Milord, infringing their right, which I dispute. But assuming to be so, please have a look to, Milord, one sentence from this Kushum Ingod's judgment, which is reported in 2004-6 SCC 254. Just one sentence. Whether it gives any cause of action or not.
2004-6 SCC.
Yes, 4-6-254.
Yes.
Kindly take, Milord, paragraph number 21 at page 261.
Yes.
A parliamentary legislation, when it receives the assent of the President of India and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. Then next sentence. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality thereof can be filed in any court, in any high court of the country. It is not so done because a cause of action will arise only when the provisions of the Act or some of them which were implemented shall give rise to a civil or evil consequences to the petitioner. A writ court, it is well settled, would not determine a constitutional question in a vacuum.
Yes.
Today, Milord, for the writ petitioner, it is a vacuum. A legislation has been passed, but unless that legislation comes and pinches you, pricks you, there is no cause of action. In fact, Milord, this legislation cannot affect the writ petitioner's any right. That is my fundamental argument.
Yes.
But even then, Milord, assuming that it can, then also, Milord, it cannot be at this stage. Where today, Milord, we are only at a stage where, Milord, a legislation has been brought in. Therefore, Milord, these are my submissions, Milord. But if required, Milord, I'll may file a one-page written notes for your lordship's assistance. Not on facts only, Milord, on the okay. Otherwise, Milord, so far as the facts are concerned, everything is dealt with in my affidavit in opposition, reserving my right of maintainability.
It's a date for
Reply. For 28, 29, 22nd. আছে 2 PM আছে 23rd next Wednesday 2 PM 23rd. Please take down. Lauded Advocate General, argued on behalf of the state applying. Argument on behalf of the state concludes. Let the matter fixed on 23rd of April 2024 for argument on reply on behalf of the petitioner. Full stop. Parties are at leave to file 18 notes of argument, if any, within the agenda.
I'm grateful.
Yes. Call the list.
Item number 4, I am for the petitioner, learned advocate Mr. Ramanand Agarwala, who is appearing in this matter. He is out of station. Kindly make it not this week.
Very not this week. Next. First call. Next. First call. First call.
My lord, I pray for Passover, my lord.
21 Lordship, I appear on behalf of the respondent.
My lord, I pray.
For the direction of filing a supplementary affidavit. I'm sorry, I stand corrected. Supplementary report, the form of an affidavit. We've already served the other side. May I also file? Your Lordship, kindly please, the order dated. Well, I am appearing for the 3rd of October 2020.
3rd of October.
3rd of October. The second report that respondents have filed, it was given on the 3rd of October. Pursuant to this leave, we are filing this supplement. Received the copy of the supplementary. We have served. The order passed on 3rd October 2023 for supplying a copy of supplementary report on the basis of their submission made on that. Calculation.
Okay, so pleadings complete.
Yes, we have also served them. We have a copy of service addressed to the advocate on record.
So what is the matter about? Whether we can start argument today?
My lord, matter grievance of the petitioner is
Ready today?
government has taken. My lord, we have filed this report. Lordship, we have also served them a copy. We have a
Yes.
letter is there. I shall check, my lord. The copy is not with me.
Okay.
Served to the advocate on record. Yes. This is file new. Served you long time. Last
Shall
year.
you use exception?
They have used an exception to the earlier report.
Earlier report they have used exception.
Yes.
Whether
This
they
is
shall
the
use it
report
or
that
not.
we have filed just now. Kindly direct the. This is the report. No. This is the first report. First, they have filed a report. No. Wait, this is the report. 15 June, 25th June.
Oh, wait.
You have the supplement. Please say it. Please correct your supplement. Sorry, my lord. Then, my lord, kindly take up this matter Monday. I have not gone through the report.
Okay.
Then they are not using an exception. Monday we are hearing the matter. Then if they are, then Monday again. I have not gone through the report. The
Okay, I
government-
am fixing the matter.
Government has taken policy or pick and choose policy for allotment of
Very
the
well. I am
land.
fixing the matter on 24th.
24th.
24th and 25 is the date when I will take up the group 1 matters. This is the group 1 matters. Okay. Very. 25th first up. 25th.
25th. Grateful, my lord.
Very well. In pursuance to the direction, in pursuance to the leave of this court dated October 3, 2023, respondent number 4, 5, and 6 filed supplementary affidavit in the form of supplementary report in the form of affidavit. Copy served. Let the supplementary report be taken on record. Place the matter on 25th of April 2025 under the same heading. The petitioner is at leave to file exception, if any, against the said report within the adjourned date
So, prior copy.
with advance copy, with an advance copy to the learned counsel for the respondent. Next.
For the petition at 22. According to the last order, my lord, state was directed to submit a report, my lord.
Yes.
3-year order. 3-year order.
4th of October, there is an order
Well, the last.
enabling you.
Don't, therefore, the no endorsement.
Okay.
Then my submission is that the petition is not maintainable. As because the petitioner is the encroacher on the government land. 10-1 notice was issued to the petitioner.
I can take up your argument on the point of maintainability today itself, if they are ready. Learned counsel appearing on behalf of the state raised the point of maintainability. So he has to be heard first.
There is a provision of appeal 10-1 proceedings only 10-1, thereafter 10-2, 10-3, thereafter 10-4. Appeal provision is there. It's not a premature, my lord, at the first stage. 10-1 notice, my lord.
What is the challenge here?
Yes, 10-1 notice.
10-1 notice.
10-1 notice, my lord. Your lordship, I'll turn to page 25.
Then one of us from high.
Was moved by another person. Pursuant to that honorable court order, not 10 these proceedings have been initiated. Well, at time, my lord. Order of the reference order of the honorable high court dated 3rd November 2022, marked in the order dated September. In compliance of the order of the honorable high court, it is September WPS supplementary order number 2. No, and the cost of the default property thereafter not 10-2, 10-3 proceedings, my lord. You have the government, you will got to, my lord, have the opportunity of hearing before the SDU. My lord, may I refer to the section provisions of the highest act.
No, why you not annex the order of the court? Where is the order? Order dated 3rd of November 2022 in WPA 182 of 49. Where is the order? Why you not annex that order? Where is the direction there? Removal of encouragement, if any.
Let me come back on next day, madam. More instruction, madam.
As you-
Auxiliary is out of station, madam.
He is not.
When?
Auxiliary is out of station, madam.
So come on Thursday, next Thursday. Okay,
Yes, ma'am.
please take down. Learned counsel appearing on behalf of the state authority raised the point of maintainability of the writ petition. Let the matter be fixed for argument on the point of maintainability of the writ petition on 24th of April 2025. Under the same heading. Next.
My lord, item number 23, I am for the petitioner matter.
Yes.
My lord, my case is this, my land has been acquired for the purpose of widening National Highway 34, my lord. And thereafter, my lord, the compensation was assessed. And thereafter, my lord, 3G5, my lord, was held by the arbitrator. And my lord, my nature of land, my lord, was enhanced. And my case is that, as per my calculation, my lord, it is about 28 lakh. However, my lord, an amount of 16 lakh and something has been given to me, my lord. My lord, in the report.
Have you received the compensation?
My lord, that I have to whether.
My lord, may I
that-
say, may I submit, my lord?
Yes.
My lord, his land was acquired as per permission of the National Highway. The competent authority assessed the compensation amount. My lord, the compensation amount was paid to him, my lord, petitioner page 18. My lord, dear Lordship, can you turn to page 18 of the writ petition.
18.
My lord.
Yes.
My lord, the payment of LA compensation notice under subsection 2 of section 3A. Name of the awardee, such and such, Dilip Kumar Das. Total amount 15,4,803. Payment and such and such.
1,54,803.
That has been paid. In case, note below, my lord, NB. In case the compensation is not acceptable, application addressing the arbitrator CB5 may be submitted to the office. Therefore, my lord, the compensation amount is paid. Next page, my lord, your lordship, can you turn to page 90, P3.
Yes.
My lord, the petitioner, my lord, made an application for arbitrator that he is not, my lord, satisfied with the compensation amount. Accordingly, my lord, the arbitration held, and arbitrator, my lord, passed the order P4, my lord. Next page, 20.
Yes.
As per position of section 385 of the edit, 9% determined and arbitrator next day taking what position. Accordingly, it has been enhanced. Arbitrator passed the order enhanced. An enhanced amount, my lord, has been paid to the petitioner. I have filed a report, my lord, the form of affidavit. My lord, it appears, my lord, the petitioner, my lord, amount has been paid. Page 66, lord.
Page 16. Yes.
70 case, land acquisition 6, compensation after, my lord, arbitration.
After arbitration.
Arbitration. Next page, my lord, they have paid. Therefore, my lord, there is no grievance of the petitioner. As per permission of the National Health Act, If he is aggrieved with the arbitrator, there is another provision of
34.
arbitration and conciliation.
My lord, I am, my lord, dissatisfied with the calculation, my lord. Whether, my lord, from the, my learned friend, my lord, annex the calculation, my lord, where from it appears 16,44,706 has been calculated, my lord, but to be paid to me, my lord. My grievances with regard to quantum of this amount, my lord. My lord, I am challenging this calculation part, my lord. I have made representation, my lord. My lord, that is at page, my lord, representation through my learned advocate, my lord. That is at page 31, my lord. My lord, let that representation be considered
How?
by the authority.
What is the provision to consider a representation?
Because, my lord, the calculation part, my grievances with
Have you made any calculation before the arbitrator?
arbitrator, my lord, only, my lord, enhance the rate in respect of, my lord, classification of
Yes,
land that is bari
there is a
VT.
provision before the arbitrator.
Page 20, my lord, will find initially it was basic rate approved by,
Understand whether you made your calculation before the arbitrator.
my lord, that is not, that representation does not speak about that thing, my lord.
Then-
Whether my legal entitlement, my lord, I have, my lord, written in my representation, my lord, will find at page 32 that, my lord, after my client received the notice, he was astonished to find that the amount proposed to be paid was rupees 16,44,706 and the sum odd, whereas the calculating authority calculated the same near about 28 lakh, my lord. I have pointed out, my lord, that discrepancy, my lord, I have pointed out in my representation. It is not the case, my lord, that I have not, my lord, spelled out anything with regard to quantum of, my lord.
Whether you have spelled out anything before the arbitrator.
My lord, the calculation part is not for the arbitrator, my lord. It is
Not
for the,
only
my
that,
lord,
my lord,
it is
period
for
has
the
already been
competent
done.
authority to calculate after the arbitration, my lord.
Page 21 of my report.
Well, it is not for the arbitrator to calculate, my lord. Arbitrator only for the purpose of, my lord.
Page 21, my lord, page 20 of my report is below the proceedings under the notice for payment. Additional amount such and such.
Page?
Page 20 of my report, my lord. After arbitration. I have got it.
My lord, I don't have any page that is 20, my lord.
দিয়ে দেবো
দিয়ে দেবো, আমাকে দেখতে হবে তো স্যার।
দেয়া দেবো
Only I have also page 19 last.
my lord only.
I don't have.
Then my lord. My lord
Give me a copy. Give me a copy. At least I can smoke it so that I can see it.
19 থেকে দেখি আমার it is our mistake that I'm sorry.
I understand.
Tendering apology. Okay. Payment. My lord. মানে বলতে দিচ্ছি পাইলাম
No, what you are referring, it is at page 18.
Yes.
Page 18. Proceeding under subsection 5 of section 3. This is at page 18. Page 18 of my report. The complete report is complete. I have the complete report, only pagination is otherwise. As page 18. This is. This matter, this. What you are,
19
no. What you are showing at page 20, it is appearing in page 18. This, yes, it is with me. It is with me at page 18. So what do you want to say? This is the calculation part.
Yes, my lord. And my lord, 19 page, my lord.
Yes.
It has been given. And my lord, she has. তারপরে কথা বলেন
Dilip Kumar Das, receipt. Without objection.
And that is my lord. That is true, my lord. Without objection, my lord, it was received. But my lord, from the date, my lord will find the payment was made on 5th December 2019, and my representation on 9th December 2019.
Repetition, my lord.
Repetition, my lord. I am not on repetition, my lord. My representation, my lord. Immediately thereafter, my lord. Immediately thereafter, my lord.
Provision of under section 34. It will not.
My lord, I am not on, my grievance is not at all with regard to, my lord, enhanced amount, my lord. Only part is calculation part, my lord. I am not disputing whatever the amount has been enhanced by the learned arbitrator, my lord. I am accepting that, but calculation part I am disputing, my lord.
What calculation part you are disputing? 30% solatium, 30% solatium after arbitration, everything is given.
My lord, if it is
Additional compensation,
my lord,
interest at the rate 9%. What you want? Everything is there.
my lord, the compensation, my lord, solatium 100%, 12% interest, my lord. Here, my lord, 30% has been given. As a statutory component, my lord, my specific case is, my lord, that I am entitled to 100% solatium and 12% interest in terms of section 30 of the
100% solatium you want?
Yes,
How?
my lord. And
How you are entitled?
my lord, the quantum of my land and the enhanced amount, my lord, that part also my lord, I am claiming that part also. Here the after arbitration, my lord, before, my lord, rate per acre, that is there. Rate per acre after arbitration. Per acre, my lord, it is.
You are referring page?
I am page, my lord, this is not paginated, subject to correction, my lord, it is 16.
Yes.
Land acquisition.
Department, district Nodia.
Calculation sheet for
Yes.
my lord, acquired land value before arbitration and land value after arbitration, my lord. My lord, here solatium has been given 30%, my lord. Solatium after arbitration, that is also 30%, my lord. That should be, my lord, 100%.
Why?
Because, my lord, the award, my lord, I can. My lord,
No, there are provisions for getting 100%, but there is some.
Yes,
there
is some.
Where is the provisions?
My lord, page 18, my lord. Now, my learned friend are saying there is no representation, my lord. My lord, kindly consider one. 18, my lord.
The grounds of the repetition, my lord, yes.
Page 18, my lord, kindly take once my application, my lord. Yes, that should be considered. I have. My lord, kindly see, my lord, the date at page 18, my lord.
Page 18 of your read petition.
Page 18 of my writ application, my lord.
You received the. This is the before arbitration.
My lord, this is before arbitration, and the my lord payment was made 11th May 2015. My lord, in terms of the my lord guidelines, the cutoff date, my lord, for the purpose of application 2013 Act, my lord, that is 31st December 2014, my lord. If the amount is paid, after that day, my lord, I am entitled to get, my lord, 100% solatium as a statutory component in terms of, my lord, in terms of the provision of 2013 Act, my lord. It is
Fine.
paid, my lord, it is paid on 11th May 2015, my lord. After that cutoff date, my lord, that is 31st December 2015, my lord, 2014, my lord. My lord, it is the guideline issued by the Transport Department. Transport Department, my lord, it was the NH Act, my lord. The provision under the Act of 2013 was made applicable, my lord.
Calculation.
I'm calculation. I'm on that my lord, in the representation, my lord, there is, kindly see the representation once, my lord. My lord, I have, my lord, here it is written, my lord, I am entitled to get, my lord, the compensation in terms of new Act of 2013, my lord. That is there.
Name everything.
My lord,
Where is your representation?
Representation at page 21, annexure P5. Paragraph number 5, my lord, it starts that now their dates of award settlement were all passed after 1/1/2015. And as such, they are entitled to get compensation as per the new Act. That is there, my lord. My specific contention is there in my representation, my lord.
That is the advocate letter, that is not the representation.
Even then, my lord, this is legal notice, my lord, representation through. My lord, it is admitted position, my lord. Award, the compensation was given, my lord, in 11th May 2015, my lord, after the cutoff date of 31st December 2014. That is specifically, my lord, stated in the legal notice, my lord. My lord, also my consideration of my representation, that prayer is also there, my lord.
Who shall consider your representation?
My lord, that is specifically that prayer has not been made, my lord.
Then,
but my lord, this is not necessary when, my lord, my representation or legal notice is there, my lord. I am entitled to have a, my lord, right of audience, my lord.
You file a press.
My lord, may I permitted to file a fresh representation, my lord? That will be considered. Otherwise, my lord, this will
Not only
my lord,
that, my lord,
my lord, a case has been made out, my lord. My learned friend will. No, my lord.
8 months. That is after lapse of.
My lord, after receiving the additional amount, my lord.
That should not.
No, that should not be. My lord, I am entitled to get the additional compensation, and if that is not adequate, my lord, I am not entitled to make representation or legal notice, my lord. I am putting this question to myself, my lord.
No, section 3H5. You entitled to interest 9%.
My lord, that calculate this prayer has been made because of the reason, my lord, the calculation
No, you are
is not
entitled to get the 9%.
is not supposed to be done by the arbitrator, my lord. It is for the Kala to assess, to, my lord, calculate the compensation. For that reason, when the arbitrator enhance the, my lord, compensation amount, it is the duty of the competent authority to determine the additional amount. They have, my lord, good, bad, indifferent, they have decided. I have received, my lord. I have received on 5th December, my lord, 2019. Immediately thereafter, I have made representation, and in my representation, I have specifically stated, my lord, that I am entitled to get the benefit of 2013 Act.
No,
because of the reason.
You have made a read that you are entitled
Because
to get
because under this provision, my lord, the competent authority is entitled to calculate the compensation, my lord. 3H5, my lord.
That's why I'm asking you to file a writ.
My lord, 3H5, my lord, they will calculate. My lord, it is not for the arbitrator under 3G5 to calculate the entire amount
Where is
after.
there 3H5?
Yes, my lord, in terms of that, they will calculate, my lord. But taking into note of 2013 Act, my lord, because admittedly the payment has been initially made after 1st January 2015. That is the date 11th May 2015, my lord. That is my case, my lord. I'm only calculation part. This is the calculation, my lord, has to be done by the competent authority only.
Yes. He has received compensation.
My lord,
without any-
compensation, this is something, my lord, which is statutory component. If it is not paid to me, even after, my lord, I am receiving that amount without any objection, my lord, I am entitled to get that, my lord. This is statutory, my lord, this is statutory component, my lord.
No, you have to make an objection there. There
My
is
lord,
provision
objection.
for made objection.
My lord, there is provision, my lord.
Then
That
why the
since it is
provision?
statutory component, my lord, it is not, my lord, their discretionary power that has to be exercised by the competent authority.
You have also not made any prayer to consider representation like that.
My lord, that is always there, my lord. Since
No, not always
in
there. This is not a representation at all. It's a letter of
my lord,
last
in that event, my lord, what I am paying before your lordship in most humble manner, my lord, to allow me to file a fresh representation in a form, my lord. I have pointed out those.
Very well. I am disposing of the writ petition and allowing you to file a
My lord, my lord.
This was the amount.
I am grateful, my lord.
Very,
And authority will consider that, my lord.
very well. Please take down. Land of the petitioner was acquired for the purpose of widening National Highway 34 by the concerned authority. Wide LA case number 35, capital A stroke NH stroke 10-11 by issuance of a notice under section 3E of National Highway Act, 3 capital E of National Highways Act 1956. Initially, the amount of compensation was fixed to the tune of rupees 1,54,803. The petitioner was aggrieved, so he made a specific petition to the arbitrator under the Arbitration and Conciliation Act 1996 and the National Highways Authorities Act 1956. Full stop. The arbitrator has enhanced the award, enhanced the rate finally. After calculation, the after calculation by the competent authority, within bracket CALA, CALA, CALA,
Competent account of the
land acquisition, within bracket CALA, an award amounting to rupees 16,44,706 was paid to the petitioner. Full stop. Petitioner received the award what is the date? On 2nd of December 2000. No, 3rd of December 2019. Full stop.
My lord, on 5th December 2019.
You have signed, the petitioner signed that on 3rd.
My lord, this represent
No,
the amount.
received on 3rd.
Third.
Received on 3rd. Received on 3rd. One representation was made by the petitioner to learned counsel on 18th of December 2017. What is the representation?
My lord, at page, my lord,
18 December.
representation, my lord, legal notice, my lord. That is at page 31, my lord. 9 December 2019.
Page 31.
31. 31 and 32.
Okay. কি বললাম? On 9th of December 2019, challenging the, making a specific averment therein that the amount which was paid to the petitioner is not sufficient. He is entitled to get an amount of rupees more or less 28 lakhs. Full stop. He challenged the calculation. He challenged the calculation made by competent authority within bracket Kala in respect of the calculation, in respect of the compensation, in favor of the petitioner. It appears that in the instant writ petitioner, the petitioner had challenged the calculation of the competent authorities in terms of section 3H within bracket 5 of National Highways Act. It further appears that the representation of the petitioner is not properly demonstrate his grievances. Having heard the learned counsel for the parties, it appears to me appropriate to give sufficient liberty to the petitioner to demonstrate his grievance before the competent authority. Grateful. By making to the petitioner to demonstrate his grievances to the competent authority by making a press representation. Full stop. Under the above observation, the instant writ petition is disposed of by giving leave to the petitioner to make a representation to the authority within 2 weeks from the date of passing of this order. Full stop. If such representation is being made, the competent authority shall dispose of his representation according to the provisions of law within 6 weeks from the date of receiving of such representation, after giving a reasonable opportunity of being heard to the petition. Grateful. Full stop. I make it clear that this court has not entered into the merit of this matter. The competent authority is at leave to dispose of the representation according to law, without being influenced by any observation of this court.
My lord, in this case, competent authorities respondent number 3. If my lord indicate that,
My lord, one more indulgence, my lord.
Yes.
My lord, one more indulgence, my lord. My lord, give that opportunity to participate in the hearing only petitioner, my lord, instead of petition all the interested parties, my lord, because I am the requiring body, my lord, the National Highways Authority.
All parties.
All parties, my lord. Great.
Okay. কি বললাম বলো, প্রথম থেকে বলো। Instant writ petition is disposed of, directing the to the competent authority, that is Additional District Magistrate within bracket LA, Nodia, being respondent number 3 of this writ petition. তারপর কি বলেছে? Yes. তারপর মেট দিয়ে কমা করো। The competent authority shall কি বলেছে বলো? After giving a reasonable opportunity of being heard to all concerned. Writ
My
petition
lord,
disposed.
only that day is 5th December, my lord. What my lord was at that time was looking at, that is my lord, payment notice, my lord. That is 3rd
No,
December.
he received on 3rd.
Received on 5th December.
5th December. Payment made by 3rd December. The payment
Signed on 3rd.
that is my lord, the notice.
Payment notice, my lord. That
Payment notice. My lord, but a payment notice, my lord, payment made me on 5th.
Paid 5th.
Payment 5th.
At page 19.
List of interested parties.
Subject to correction, my lord, at page 19, my
Okay,
lord.
last page.
Last.
The policy received on ওটা হচ্ছে 5th.
Next two matters, my lord, I am praying for 1 week adjournment. because
Which
of the
matter?
particular 24 and 25. Adjournment, my lord. I am praying for 1 week adjournment.
24 and 25.
Yes, my lord.
Today we
My lord,
don't have
I-
time.
One week adjournment, my lord, because on the ground of a.
Usually I will
Ashim
take
Kumar
up these
Gang-
matters on Friday, Thursday and Friday.
My lord, 1 week adjournment because it has been instructed by my senior who is leading me.
It
Ashim
will
Kumar
appear
Ganguly.
tomorrow. It will appear tomorrow.
My lord, 1 week adjournment has been asked for, that's why. my lord,
Very well.
I
24 and 25, not this week.
deeply. So 1 week adjournment, my lord.
Not this week.
Deeply. Next. তারপরে থাকছে automatic.